So good morning and very good morning to all the honorable ladies and gentlemen at Sikkim. It's my huge privilege and honor that the honorable academy has sought me qualified enough to speak to you and be here. I'm really grateful for this opportunity. So, sir, madam, we are talking of domestic violence here, and I believe all of you have had sufficient exposure to the law and all the issues related with it. Unlike me, because when I was a magistrate, this act did not come in effect. It was notified much earlier. I became a magistrate in 1999. I mean, you remember, some of you were probably not even born. So, I came across this act for the first time as an appellate forum, because the appeals were to be filed before the sessions court. So that's how I got introduced to this law. And after this assignment, I was directed by the Honorable Director, Judicial Academy, that you have to speak on the Domestic Violence Act. So I had to read this law anew. Now, about the problem of domestic violence, about the problems that you people are facing in executing this, in my understanding, this is one of the most wholesome, one of the most holistic legislations of independent India. I mean, that's my understanding, and I do not know whether any other country is having any other law parallel to this or to this, of this magnitude, so far as social and restorative part of judicial system is concerned. I am not aware of. If any of you has come across, please enlighten me, because this whole day is not dedicated to me speaking and you listening. It is more, for me, it is more of an exercise for me to learn as much as you do, and we have to have an exchange of knowledge and information which you may have, I may not have. Very likely. So I did prepare a PPT because I was almost told that I have to do it. My exposure to my first practical exposure to this thing, Domestic Violence Act, came for the first time when I was, as told by the Deputy Director, when I went to US. So we were taken for the first time we were taken for, it's not showing there, gentleman who is taking care of this. When I was taken there for this IVLP program. So we were taken for, ये क्यों नहीं आ रहा है? यहाँ नहीं आ रहा. Yes sir, मैंने खोला है. अच्छा, okay, there. Thank you. So I'm not that technically sound, forgive me for that. So we were taken for an arraignment hearing. Arraignment is something they call bail application. I did not know that time, and I was introduced to this word. And there was this man who was produced before the judge or magistrate or whatever they call him. And unlike our system, the victim was there, a lady. You know, she was all, like you see in movies, the very physical evidence of violence, black eyes, coon, all this, everything was there. She was in very bad shape. And the judge asked her, first thing the judge did was not hearing the prosecution or defense. He asked her, madam, what do you say? He is asking for an amendment. What should I do? And the lady said, like it was, I am just reminded of that, probably for the first time after that hearing, she said, there is no food at home. So, you know, that is where we come down when we talk of domestic violence. And that is the idea from where this whole legislation came up, in my understanding of things. It is not about punishing him, beating him, putting him in jail, putting him to death. It is not about that. It's about bringing in a situation where everyone is, able to survive with least dignity possible, at least. The lady didn't say, I don't want bail or I want bail. The first response she had was, there is no food at home. So, when in when I came across this law after 2011, I became a session judge in 2011 probably, whatever. So I got the appeal after that, and that thing was, that this whole idea, the whole idea of making even section 32 when it talks of making the offences and the derelictions non-bailable and cognizable. Parallel to that, the rules laid down probably in rule 16. I am not very good with the numbers, so you have to cross-check with that. That's why I am carrying this. The rules say that if is allowed or if bail is allowed, these are the conditions of bail. So you are not to treat him as a criminal. The procedure is a combination of civil and criminal only because the criminal part comes in when he does not conform to the order, when he does not comply the order, or when there is a dereliction, or when there is a threat to the life or security or well-being of the victim or the survivor, whom we are calling a grieved party here. We are not even calling her victim here or survivor here. I don't know what to do. Yes. So there was one structure, it must be there in front of you, which was given to me. So conduct of cases and all that, I have not been able to prepare this like sequentially with that, but I'll try to cover all of that, the job given to me. So the procedure part, as I told you already, is a combination of civil and criminal procedure. How? Because it is called information when it is lodged before the magistrate, a summon is issued, unlike a criminal proceeding, primarily where we go with police and warrant and arrest and all that. So those things are done away with. So there is a summon issued to the AP, to the OP, the opposite party. Now you all know, see, please point out where I am wrong. There is every possibility that I have erred in interpreting and understanding the law. So either the complainant, the informant, the aggrieved party herself, there is no locus standi here. When we come to procedure, the first part is there is no locus standi here. Anybody who has come across the information, you may be a neighbor, you may be a passerby hearing something happening inside the house, you may be any person working, person related, not related, totally foreign to the whole situation. If you come across this, you may inform and nobody will question your locus standi there, unlike normal criminal law. So that is an expansion. This whole law is pretty much an expansion of the legislative intent, and they have tried to enter inside, they have tried to penetrate inside the social structure of legal system. So anybody who comes across comes to know that there is something like that going on, they may inform. They may inform the protection officer, they may inform the magistrate. About protection officer's role, we have a second part, I'll take care of that. So there's a combination of civil and criminal procedure. All the proceedings, section 12, 18, 19, 20, 21, 22, 23 and offences under section 31 shall be governed by CRPC. That's the primary thing. But honorable courts have said it time and again, many times, that the whole of it has to be civil and it turns criminal only when there's a dereliction. Having said that, the magistrates under this act have huge power. This is the only law in India where magistrates have inherent powers. You have discretionary authority under magistrates. You can invoke any proceeding you want to if it is required to fulfill the requirement, right? Nothing in subsection 1 shall prevent the court from laying down its own procedure. By own procedure, the legislatures have given you a wide, long hand, कानून के लंबे हाथ, literally. So I have even in this PowerPoint you will come across, I have at one place mentioned in Kolkata, one officer who happened to be the additional chief judicial magistrate of Salt Lake, Kolkata at that time, which is under North Chobis Pargana. He passed an order. Both the parties have submitted long affidavits of assets. So there were huge statements. You know, it happens if somebody is a businessman, if somebody, a lot of statements were there and all that, income tax return and all that. And the magistrate thought, because they have huge pendency and lot of cases, that I will not be able to do justice to it, I will not be able to go through all of it to make out what it means. He appointed a local inspector like we do in CPC for local inspection. Somebody goes and inspects the house and submits a report. He did that in DV Act, and the opposite party challenged it, and Honorable Calcutta High Court upheld the order. Right? So, you can be, this is one law where you can be very innovative. You can invent your own ways and means within the framework of law, civil and criminal, and you can take help of any outside agency, again within the framework of law, so as to enable you to fulfill whatever is expected of you from this act, right? So this is one reference that I have noted here. This PPT I am leaving here, so please don't take pain in writing it. You can all have, I have already requested that it can be shared with all of you if it can be of any help to you. So again, in this judgment, Honorable Supreme Court said exactly what is there in the law and added that the purpose of enacting DV Act was to provide remedy by amalgamation of civil rights of aggrieved party. Intention was to protect women against violence of any kind, especially that occurring within the family. As the civil law does not address this phenomena in its entirety. What happens? Civil law takes care of one part, the property, the rights, the status and all. And the criminal law takes care of the other part, that is punishment. Simply penalty, nothing else, in whatever form. So, we needed something that took care of both. Women till date are not reporting domestic violence incidents only for one reason. Kaha jayenge? You know, I hope I will be using Hindi once in a while, so if it is a problem. So where will I go? Because in rest of India, Sikkim probably had a background of a matriarchal society. So women in hills, I have worked in Kalimpong, I have found women in hills are very strong, are earning, are running the family and dictating terms also. Except when there is not much influence of the outside society, which is really, really unhealthy and very, very, very patriarchal and very misogynistic. When this situation is not there, when we are reading the Domestic Violence Act and all its purport, we have to understand it was drafted with the whole of India in mind. Think of Haryana, think of Rajasthan from where I belong, think of Bihar, Uttar Pradesh. They don't have a matriarchal society, women are treated as commodities. So once a girl is married off, the parents also wash off their hands. I'm not being unkind to any of them. I'm just narrating the situation that actually prevails there. So if there is any problem, most of the 304Bs I have heard, most of the 498As that I have heard in this around 26 years are because there were differences, there were assaults. She came home and somebody said, ठीक हो जाएगा, समझा दिया है, adjust करो, बच्चे होंगे तो ठीक हो जाएगा. And it continues till the day when she probably dies or she probably gets so used to it that she doesn't even bother informing. And the children learn the same, they see that this happens and nobody takes care of. So this is the way. I have heard a victim's son, very young son of 6 years, saying in court, he was speaking in Hindi, बाबा बोले हैं गलती करेगी माँ तो मारूंगा ही ना, तू गलती करता है तो भी मारता हूँ. And he was getting acclimatized to that violence. Why? Because the mother had nowhere else to go. So this is the law which took care of that. They provided a residence, they provided a right to residence, they provided that if you don't have a home big enough, you give them the rent so she can live. So once she is married, once she is your wife, once she is in a domesticated relationship of whatever nature, you ought to provide her shelter also. कि छत नहीं है इस डर से वो उस अन्याय को सहते न जाए. Right? So what reliefs may be granted, you are all aware of this. This is all there in the law. The monetary, the residence, the compensation, the everything, I mean, all of it that is there in section whatever it is there. Section 18, magistrate may pass protection order. 19, restraining order from dispossessing or disturbing. 20, monetary relief. 21, custody of the children. 22 compensation and damages, 23 interim ex parte orders, all of it you are aware of. I don't need to read the sections anymore. Now there is a big question here that when you are giving, even custody, a thing can be decided by a magistrate. Now tell me, there is a Hindu Marriage Act, there are applications for custody before the district judge. So how do you do that? There are areas, there are grey areas. It says that section 10 CPC may be allowed, will be applicable. There is a provision which says section 10 CPC will be applicable. What is section 10 CPC? Stay of suit. When one suit is pending and another suit is filed, suit or proceeding is filed and the matter is already in dispute somewhere before some proper court, then the one will be stayed, the subsequent one will be stayed till the earlier one is disposed of. Now those things will happen, There are cases I have probably mentioned here also. There have been situations before on the Supreme Court when in civil court the father-in-law filed an application saying, asking for declaration and mandatory injunction, and the daughter-in-law has already, she has a pending application under DB Act, or she may be in a situation where the application is not yet pending, but the situation is such that it is filed, the father-in-law has filed it only because he wants to oust the daughter-in-law. So those are areas, those are grey areas, there are certain solutions given, and most of the time solutions are not there in the law, but as I said, this law gives you a long hand and you may be very proactive and you write good orders, write audacious orders. Like that would be my suggestion as your senior in service, I take that liberty. Write audacious orders, let them go to high court, let new law come up. Let them define what are the limits of your power within this act, because this act says you can promulgate your own procedure. That's a huge statement, like 126, like 32, like the Constitution. You can do things. So you are very powerful there. Use that. And don't think that this is a simple case. ये तो किसी और केस में होता होगा, कुछ बड़े बड़े केसेस में ऐसा होता होगा, सुप्रीम कोर्ट में होता होगा, ऐसा नहीं. Every case that goes to Supreme Court has initiated from your benches, right? You may remember that. Somewhere it has originated from some learned magistrate or a civil judge or some learned judge of your seniority or even junior to you. So it is not like I don't have to write this. No. अभी अपील में जाके क्या होगा? सेट असाइड कर देंगे, फिर हाई कोर्ट में जाएंगे, तो हाई कोर्ट को लगेगा ना, how does the law evolve? The law evolves, the law grows. People who are the target audience of law, those who have suffered, those who are victims, those who are survivors or aggrieved party, they are the ones for you whom you exist. You don't exist for the High Court. I mean, pardon me for saying that. You exist only and only for the aggrieved persons who are there before you. So write audacious orders. Make use of every provision of law. Let them interpret. Let them define, let them say the magistrate what not to have done that. You never know. Once in a while they may say, congratulations, you did this. That is how the magistrate should work. They may say that, but you have to give them that opportunity. Honorable Court can lay down good law only when you write good or bad orders, not when you write the stereotypes, revenge orders. They can't, because nobody would be aggrieved. Nobody would go, right? So the interpretation and evolution of law by judge-made law depend entirely on each one of you, right? So section 26, relief in other suits and legal proceedings, is like there can be parallel suits also. There can be suit under Hindu Marriage Act, Hindu Adoption and Maintenance Act, Domestic Violence Act, 125 CRPC. All of it can be there parallelly, and we will discuss Rajneesh and Neha where we have the protocols of how when parallel proceedings are there, how you can take care of one and how it is to be adjusted and there is no double jeopardy or there is no overlapping of jurisdiction. That has to be taken care of. So any relief under section 18, 19, 20, 21, 22 may also be sought before civil court, family court or criminal court, right? In case any relief obtained in any proceeding other than a proceeding under this act, they shall be bound to inform the magistrate. Those are very basic premises of law, that anybody who comes to court, if he has any order of any other learned court, he or she has to inform, else it is like not coming to court with clean hands, and the court will take necessary steps on that, right? So then how can you give interim and ex parte orders? You have the affidavit, you have the party, you hear her, you hear the protection officer, and you grant ex parte order. And I'll encourage all of you to give as many ex parte orders, interim orders as possible, because I have had magistrates, I have been a principal district judge, so I have heard, we have had meetings and we have heard, and I think because we are in-house we can discuss it. There are magistrates who are wary of giving interim or ex parte order in DV Act. Because in DV Act the interim order is not about like 125, सिर्फ पैसा दे दिया सब, आप रहने को दे रहे हो. So there are people, there are officers, and till date majority of magistrates are males, at least in this Bengal. I don't know about other states. So due respect to you sir and you sir, I'm not saying they are biased, but yes, it does affect. I have to say, in more often than not in cases, it affects the way I have been brought up, the way I have seen things, my perspective, all of it affects my adjudication. I can never bring a judge out of a judgment. You know, the very spelling judgment contains the word judge. You cannot bring it out. So a judge's subjective preferences and inclinations are reflected. That is why I'm saying, I'm advising and I'm suggesting, please try to give as many interim orders as possible, because somebody coming to you informing that it is unable for me, I am unable to live in that house, that the tortures and all are becoming unbearable, and you saying let the husband come and they will hear. Do you understand what happens in between? Do you understand in between whether she will be alive to you come to you? You don't know. You don't know how she will be driven out. You don't know how physical force will be used on her. You don't know where she will go. And you won't even, the interesting thing, the most unfortunate interesting thing is that you would never come to know. That will not come to court. So many pressures are there on a woman to survive. So, at least see that you can ensure, or you can at least try to protect that she has she has something, she has come to you. It is not easy for a grieved party in a domestic relationship to be able to leave that house and come to court, because she is going back to that house only. Unlike a victim of say theft or even murder or somebody, they don't have to go back and live in the house of the accused. This is the only law where the victim has to go back and live with the accused, who are in general more in number and more physically empowered than she is. Socially to chhodi diji, even physically. So you have to, once she has the courage of coming to you, don't disappoint. Please don't disappoint. I'm saying this not by presuming that you are disappointing. I'm believing that you people are totally doing what is expected. But because I am seated here, that's just my good fortune, not that I'm qualified for this. I think I should just share the concerns that I have about the law. I do not believe you need to learn the sections all over again. You are all aware of it. So, section 31, the procedure becomes criminal and it has to be under section 32. The procedure for taking cognizance as per section 32. These are all cognizable offences. Non-bailable is there. But about bail, I am not saying much. Honorable Supreme Court is saying a lot about bail every day now. So you people can go through and understand how bail works. So I do not think in DV Act you will not grant bail, because even in PMLA cases you have to grant bail. I mean almost, that is where we stand. So about bail you have to understand your responsibility and deal with it. But the law says this is a non-bailable offence, cognizable and non-bailable. Criminal procedure, section 32. I don't need to read it. So upon the sole testimony of the aggrieved person, out of this whole template that is there, what is most striking is, upon the sole testimony of the aggrieved person, you can't start with this belief, like a boxer victim. You can't start with disbelief. You have to start with believing. And then when the disbelief comes, it's like very much a French jurisprudence. It's very much unlike Indian jurisprudence. In Indian jurisprudence, we start everything by disbelieving the person who is informing. You disbelieve the FIR, you disbelieve everything. You disbelieve. Actually, as a trial court, you disbelieve, and the prosecution has to take pains in proving it by bringing medical reports, by going through cross-examination, a lot of procedures. But this is the only law where the law says upon the sole testimony of the aggrieved person, and here testimony does not mean cross-examination. It does not mean cross-examination, it means statement on oath only. So when she comes and says it was not complied with, you do not put him on dock and present her for cross-examination. क्यों तुमको कुछ बोला था क्या? तुमको दिया नहीं था? तुमको रहने नहीं दिया था? अच्छा खाना नहीं दिया था? दिया तो था, तुमने मना किया था. It will not work like that. It will simply, the victim will come and say, see, you told me that I'll be able to live, but they put all my household articles on the road yesterday and told me that I have to leave. I can't live there like this. You have to start a proceeding under section 32 on the basis of that statement only. And then it becomes a cognizable offence. There the procedure is no more civil. So you have to become very uncivil there, if I can say that. You have to use police, you can issue warrant, it has to be produced or can appear, and then it will proceed as that. So, then execution of orders. This is section 31, read with rule 15, you know how it is to be executed. Do I need to tell you? I can if you want, I love to talk, so I can. But then, the general principles are, especially in case of violation of protection orders, that is section rule 6, complaint case under section 498 is to be lodged. There are rules and responsibility of protection officers also. I'll be able to tell you that in the second part of this thing. By invoking provisions of CRPC, police may also be compelled by court. Because court has a long hand, court has used that, court can send the officer. The officer in charge also has some duties assigned under that. The officer in charge will be, the protection order will be sent to the officer in charge. The protection order will be sent to the officer in charge, and the protection officer will liaise with the officer in charge also. So police comes in play. Once it is not followed, the police comes in play. The difficulties, section 26 can be invoked by magistrate for enforcement of monetary relief without any, this is my input, I do not know how far it is true, but I believe it was, without any application if OP is a salaried person. There are very few instances of such suo motu exercise of power. One, if you are informed that he is not giving, you will not suo motu exercise normally, otherwise then there is an application. That is one part. Second is, when the OP is self-employed, not very few people, like I don't know the percentage, but it's a very little percentage of population in India has a government job or has a salaried job. So what about those who are self-employed? The rickshaw pullers, the toto chalaks, how do you implement that? Because you do not have a salary where you can direct the bank ki aap itna paisa bhejenge, right? So those are some difficulties. There again I'll say, I'll encourage you all to invent ways and means how to implement. अगर किसी के पास टोटो है, पता करिए whether it is old, because you have a machinery at hand and you can use other machinery also. The law gives you a long hand here. You can use police, you can use protection officers, you have other counselors and all that, the service providers. You can have a report from the owner whether the vehicle is owned by him. What is the general, like this thing, income, the normal in that route. You can seek statement from the transport authority, what is the normal income in that route, they will give you. We have done that. There has been instances. You can procure those reports and you can pass those orders. कुछ नहीं है, अगर एक vehicle है अपना जो चलाते हैं आप उसको भी सीज कर सकते हैं. I am being very harsh on men. I am not. I am trying to find ways through which I can help those who are unable to take it only because the man does not have a salaried income, right? When there is a salaried income, you can just simply send the order sheet. Execution में जैसा करते हैं 125 के बाद जो 128 वगैरह में करते हैं, simply, or even civil cases you do that. In execution, when there is a monetary relief, you send it to the bank manager and tell him, okay, you confiscate such amount of salary, transfer it to such bank, which is easier to do. But when there is a non-salaried person, self-employed person, you have to think out of the box and find out ways and means how to execute the order. Make sure your order is executed. It is on you. You cannot simply write and sign and then say, nahi maan raha. You can't do that. In DB Act, you can't. I do not believe you can do that in any other act, but in DB Act especially, because you are the one where she has come after, a long struggle she has come. So you are the one who have to do everything, find out ways and means how to implement it. Because I thought that is one area where the law could have been more, vocal, but it is not. So that is a good thing in a way. When the law does not specifically demarcate your authority, I believe it is good because it allows your judicial self to think, to evolve and to act. So that is something that you can use. कैसे करना है? और वो कैसे करना है में ना? Think unconventional. Because you as a judicial person, as a judicial officer and the protection officers also, I say a judicial person because they were even part of the judicial system, you have this judicial conscience in you, mind that. कहीं भी कभी भी चले जाओ, even if you are going for sabji shopping, you have this judicial conscience in you, right? Use that and you will never fail. In all honesty, with empathy, if you use your judicial conscience, you will never fail. You are not going to doesn't matter. There are forums and there are times. You never know, after 10 years it will come to be a law. It has happened with me. We will discuss it if we have time, but today we have to confine within ourselves, the job at hand, so I will just confine myself there. But it happens. Even the law changes because you passed an order. You have to have belief in yourself, right? Use your judicial conscience or this bindas come right? So penalty for breach of protection. A breach of protection order or an interim protection order by the respondent shall be an offence under this act and shall be punishable with imprisonment of either description for a term which may extend to 1 year or with fine which may extend to 20,000 rupees or with both. Now here again like 128, we have lot of consonants with 128 and the whole CRPC thing. I am not much aware of the BNSS and BNS and all, forgive me, I am not using those terms. So much बोलना कि नहीं है, गलत बोला. So there's a whole lot of, like 125 there was this thing that 1 month. So there were lawyers who were very innovative and what the lawyers are very innovative, I really know of them. Like somebody did what they did was for every month's default, they used to file one case. For 1 month's default, OP will go to jail for 1 month. So it is like, not like 1 साल बाद ही करना है. Not like 12 months default you will get 1 month's jail. It is not that. Right? You can do that, You can do that. So in this case also, 1 year does not mean only one, एक ही बार होगा, ऐसा नहीं. उनको एक बार घर से निकाला या एक बार तंग किया या एक बार आके उसको डिस्पोज करने की कोशिश की, एक हुआ, फिर अगर 1 महीने बाद किया, प्रोटेक्शन ऑफिसर आपको इन्फॉर्म करेगा, आप लगे रहना. You know the advantage of having less cases is, I had less cases in Kalimpong. You can work on each case आराम से. कोई हड़बड़ी नहीं है कि 3000 रिकॉर्ड्स है, जल्दी वो स्टैम्प वाला क्लरिकल रिकॉर्ड ऑर्डर करो, ऐसा नहीं. आप हर रिकॉर्ड पूरी आत्मा के साथ, पूरे मन से कर सकते हो, आराम से लेके हर रिकॉर्ड, हर रिपोर्ट बहुत माइन्यूटली पढ़ना है. और कहाँ you get one word, whether it is in OP's response, be mysterious. You get one word and use it, right? Because this is one law where the property of relatives, the act of relatives, if the OP has transferred property to some other person to protect himself or to defraud the AP or to, not to defraud, maybe to, what is the word? उनको वो करने के लिए, उनका नुकसान करने के लिए he does that. You can catch them also. Because you are not, primarily you are profiting on the civil law, right? So the breach, it can be extended whatever. The offence under subsection 1 shall be as far as practicable be tried by the magistrate who had passed the order. They are using the word mother court, which is a very, very good provision, I believe, because you are the one who has dealt with it. You have the knowledge, you have the empathy, and you know all the facts under which that order was passed. So you are the best person to execute it. You have the passion for that order. You wrote that order. So आपके पास सारी शक्ति के साथ उनको you will try to implement that. So the execution authority is given to you preferably. That is the wording used by them. While framing the charge under subsection 1, the magistrate may also frame charge under section 498. That is there, you can do it. Now Rajneesh versus Neha. Now what I have done is, this is an error on my part, I must confess, about all this structure that was given to me. I have done lot of idhar-udhar. So you can please understand that I am doing it sequentially, right? I am not doing it sequentially. So this Rajneesh versus Neha is there. Where did they put it? Civil and criminal procedures, trial of offence. Okay, this is in the second session. Where is that?
Just before writing
Okay, there it is. Okay. So how much time is left in first session? We have time left. It is now 10:45. So 11:30. So we can do this Rajneesh versus Neha now. Is it all right with all of you? Or if you have anything about this thing, because we have covered the first session ka detail. If you have any questions on this, we can do it now, and in the second session we can do Rajneesh versus Neha and protection officer. What do you think? I can do with Rajneesh with Neha today? Now? Okay. So, you are pretty much again aware of what were the directions. Still, wife can make a claim of maintenance. No bar to suit maintenance under DV Act, Hindu Maintenance Act, Hindu Adoption and Maintenance Act, or any other law. Two proceedings were initiated by a party would not imply that one would have to be adjourned sine die. Section 10 will be applied here. That is there in the law. See, the directions of Rajneesh versus Neha, you have to go through that, the Gita and Quran or whatever, but read the act and the rules and take care that in implementing, because that's the law of precedent. Whatever precedent is there when you are dealing with certain things, there cannot be two identical cases. There cannot be. So wherever your realities are different, read the law, take care of that, right? Don't just simply क्योंकि Rajneesh versus Neha में बोला है तो यही करना है, ऐसा नहीं. That you will end up doing something that is probably not the healthiest solution for the problem that you have before you, right? Take that as a philosophy, and the action has to depend on the facts that are there before you, right? There is a distinction in the scope and power exercised by the magistrate and the 125 and a minimum. Of course there is. 125 deals only with maintenance. It does not have any residency. It does not give you the inherent power of using a procedure to your choice. So there is lot of difference, and there is lot more scope on your part under DV Act. We have already discussed that. An order passed in the maintenance proceeding would not debar re-adjudication of the same. That is also there. There is an order of maintenance before the district judge in the divorce case, and there is an order of maintenance 125, and then there is a DV Act. So first, section 127 CRPC by itself says it can always be re-adjudicated whenever there is a 127 or 126, I don't know, and if I am wrong, please correct me. That it can always be altered or amended or enhanced or decreased on the change of circumstances. Suppose the wife starts earning, it is decreased. Husband gets a bigger, higher salary job, it will be increased. Like that. So it is always amendable, it is always alterable on the change of circumstances. Like the wife remarried, there is no maintenance for the wife, right? So this is always there. This is the law that has been reiterated in Rajneesh versus Neha. Procedure 125 are summary in nature and are intended to provide speedy recovery to the wife I am very I'm saddened to say that summary proceeding is a word that is more used in letter. It is not used practically. So for all practical reasons, 125 maybe we have witnesses, we have cross-examinations, we have OP's evidence, cross-examination. It becomes all the same. I have never come across a situation where I felt that because it is 125 and the procedure says, so for that reason it is done fast. I have not. So summary proceeding, of course, technicalities are there and that can be adhered to. For all practical purpose, you have to be very cautious to consciously thwart any attempt to delay, because this is something that is urgent. It very much, see, the whole act was enacted to prevent vagrancy, to prevent destitution, to prevent a situation where women and the children are homeless. So you have to act with urgency. 125 also has that only, because it was enacted long back when the DV Act idea was not there. So that was the only solution we had at that time. So any order passed under 125 by compromise or otherwise would not foreclose the remedy under section 18 of Hindu Adoption and Maintenance Act. Now this is something that I can very well relate it with that when DV Act there's a rule in for protection officers के बारे में जब बात करेंगे, then we will discuss that the protection officers will the counselors will act as mediators, more or less. They will try to do settlement, they will try to talk to parties. So whenever there is a settlement order, there is a compromise order, that will be given effect to by that court, but it does not debar other courts. Now you can ask me, I would have asked, what about estoppel? What about the very basic law that when I am saying I will not have water, can I after a few moments say you did not serve me water? The very basic estoppel thing. Compromise this one. I am saying I want this. So in a future proceeding, on the next proceeding, can I say it was not given to me, or can I say I want it? It is provided here. It is a antithesis of the law estoppel, because there can be change of circumstances and it can be very frequent. It can be psychological, it can be physical, it can be very practically there. So even in case of a compromise, you can in future, you have to, in such situation you have to deal with lot of factors. You have to see whether there was any change of circumstances. Is it only whim? You know, it's only mera man, it's not that. There are circumstances, there are reasons why she is deviating from the compromise, or why she is asking for something other than what you agreed on. And if that is judicious, again your judicial conscience here to you. If that is something judicious, you cannot bar her only because you did it on compromise. So there again, this whole act I am telling you has at many places stressed itself. The legislatures have stressed themselves to accommodate the necessities and the needs of a aggrieved party. The AP shall disclose the same before the magistrates, so that is there in the law, of course, and adjustment is permissible. Of course, you can't, the poor husband only because he is born a male, I am doing this because only 2 males are there, we are all ladies here. You can't make him suffer and you can't do things. When you are judicious, you have to be judicious to each of the parties that are there before you. So when it's monetary relief, you have to adjust, you have to understand. If the salary is 10 rupees, you cannot award a maintenance of 8 rupees. Taking in consideration of all the orders of Hindu Maintenance Act, of Domestic Violence Act, of 125 CRPC, you have to come to a place where it is adjustable, where it is judicious. The ultimate figure has to be judicious, right? So then there is affidavit of assets and liabilities that is there in the law. Maintenance proceeding, both the parties, post must direct additional and further information if court so goes. When you go through an affidavit of assets, especially it happens when there is an affidavit of assets by the husband. When you go through it and you see that there are important information missing, which it in all probability will have, Please feel free to ask for additional affidavit of specific points. You have every right to do that as magistrates. Even as a protection officer, you can direct and you can request that this is to be filed. Right? You understand? Court may invoke provisions of Order 10 CPC, as I said. This one will be stayed, and 165 Evidence Act is always there. What is 165? No, I am not looking for examination. You can ask any question. You can ask for production of any document. Like I said, that किसी ने ऑटो चला रहे हैं, आपको पता करना whose own है. You can ask. You can direct production of ownership document. You can direct the RTO even. You can under section 165 CRPC, Evidence Act, sorry, you have, if I may use the word, you have unfettered rights. You have unlimited rights. Even in one judgment on the Supreme Court said, the court may ask irrelevant questions. Irrelevant, can you imagine? No, that is not what you will do, I believe. But this is only to say that you have your authority at 165 is immense. Don't confine it to DVR. In any trial that you are sitting, in any case that you are sitting, you can use, and do use this. Do use this. Medical report नहीं आया इसलिए victim को acquittal हो गया. Don't do that. Direct the CMOH, direct the officer, direct the medical officer who has attended to the victim to produce it. Even if the victim, there are times when the victims have it at home. They do not know, and the whole thing ends. And the judgment is passed and she did not know that it has to be produced at any point of time. Nobody told her. See, you are the judge. Don't leave anything for the advocates. Section 165 Evidence Act says that. Will you sit on one of the benches? No, you will not. Will you sit for the prosecution or defense? No, you will not. But you have the duty of bringing out the truth. And for that, Section 165 says you have to act. You cannot say prosecution का काम था, defense का काम था, मेरा काम नहीं था. If I act this, the prosecution will say, sir, you are prejudicing the prosecution. The defense will say you are prejudicing me. No, I am not prejudicing anybody. I am by the side of truth. I have to have all material. Maybe the injury report will come and show that there was no injury. Maybe you do not know. So it may end up helping totally the defense. You are only on the side of truth. So while we are discussing DV Act, this is pretty much part of our itinerary as a judge, as a judicial person, as a person who is part of the judicial process, whether the judge, whether the protection officer, whosoever. Your job is to be by the side of truth, right? So when you are a judge, you are armed with Section 165 Evidence Act. You can use it just like in any other case. You can use it in DV Act. That's what the Supreme Court reiterated in Padnis versus Neha. What is 106 Evidence Act is presumption. You know that. If somebody is not producing some document, DV Act by itself has also laid down. If the husband does not produce his income statement, you have to have adverse presumption. So you can depend totally on the affidavit of the wife and pass an order. And the husband cannot cry wolf that you did not hear me. You only denied. You did not produce any document of your income. You cannot now come. So the 106 Evidence Act also says that adverse presumption, and DV Act also says that adverse presumption. So it is on you, it is not on court. If you are not saying what you have, I have to assume. If your wife says you are Ambani or Tata, I believe that and I write you. Right? So the adverse presumption thing will also come. Section 10 we have already discussed. Section 165 we have already discussed. Section 106 we have discussed. Treating may be changed. So here again, this is another example of how this Order 617 of CPC is being used in DVA. You can add, you can change whatever is there, you can bring to court, right? Amendment is allowed. In plain language, amendment is allowed. Court must decide interim maintenance application within 4 to 6 months. Right? That is a dictum of Honorable Supreme Court. Because it is interim, I will say don't wait for 4 months. What do you do with ad interim applications when you are sitting as a civil judge? the first day you write the order. Ad interim का order पहले दिन लिखते हैं ना, balance of convenience, inconvenience है कि नहीं, irreparable loss का apprehension है कि नहीं, you write it first day. My house will be broken, they will erect a wall, something or the other, and you are like, yes, I have to write the ad interim order. What happens when there is a victim who is coming to you, I am thrown out of my house? Is it less important than building a wall or breaking your house? It's a life, come on. Don't wait for 4 months. If the ad interim application, if the interim application comes, deal with it as an ad interim application. Write the order on the first day if possible. See, you as a judge, you will sit, you will read and you will understand. Will you not? You will just read and you will understand how far true it is. Or here too you are armed with the protection officer, with the police officer, with the counselor, with the service provider. Lot of hands you have. Whether those hands are working or not, that is different. How we can make it work, that is also on us. But you have hands. If you have an honest intention, you can use them. So the moment the lady comes to you with some application, don't wait for even 4 months. Try to write something. If not monetary, at least residence, at least chat plus. This much you have to do at the, with very with lot of earnest on your part, you should do it. And thereafter you can dispose of this interim maintenance application after having whatever. If the OP comes, then it is not no more interim. If the OP comes, it is the final. They give their reply and you hear both of them and you write your order. That's the final adjudication of the maintenance order. Age, employment, qualification of parties is a relevant factor, right? How old is the victim, the aggrieved party? How old is the OP? What is their income? What is their qualification? These are important factors. Health conditions, these are important factors because this will tell you about the requirement, about the helplessness, about the capacity. So these are the factors that you have to think of. Magistrate may direct the opposite party to secure some level of alternate accommodation and direct him to pay rent. If it is very uncomfortable, which it is more often than not for the aggrieved party to stay in the same house, then in that event you can just direct him, arrange for it. There are times when the wife is not able to find an accommodation not in the same locality. She will prefer the same locality mostly because it is convenient to her. She knows the people, she knows the neighbors, she knows the grocery store, maybe the child is studying in the same neighborhood school. So she will prefer it, but she may not find it. I have come across a situation where the wife was, there was a multi-storied building and the wife was denied rented accommodation in any other flat because the husband was powerful in that committee of that community. There's a committee of house owners and all that. She was not allowed because the husband is living there in his farm. He does not want his wife there. She wanted to be there. Why? She wanted to see her son go to school, come back. The custody was not with her because she had to come out. She was assaulted and in the middle of the night she had to come out. Now, those are situations where you can use your other hand. You can use your machinery to find out, you don't use your machinery here. You direct the OP to find out an accommodation for her which is suitable and to her choice and then pay rent. You can direct that. You can be innovative here, you can ensure that she gets an accommodation. You cannot just leave it ki, theek hai, AP to find out an accommodation and the OP will pay rent. You can do that also, but when the AP is having difficulty, you can please direct the OP to find an alternative accommodation to the choice of AP and then pay rent. Until that time, he has to accommodate her in his house, make it as comfortable as possible for him and for her, not for him, for her. Section 2S read with section 17 and 19 entitles AP right to residence notwithstanding her or OP having any right, title, interest of the same. Now this is very important, a guideline. What happens is the husband comes and says the house, I don't have a house, my father's house, my mother's house, or this is my uncle's house or grandfather's house. So here the right and interest of the OP is not important because they were living together, right? Now there are other issues related with it, we will come to that. So even when the wife is earning, maintenance can be awarded to enable her to maintain herself as per the lifestyle of her husband. So the wife is earning say rupees 10,000 per month and the husband is earning say rupees 1 lakh per month. Normally in our society, Unlike, like I'm not counting in Sikkim. As I said, Sikkim has a different, much more healthier social structure so far as gender balance is concerned. It is healthier in my exposure to your neighbor Kalimpong. Normally the husband earns much more, and that is how the marriages are set, that the husband has to earn more, the husband has to be taller, the husband has to be, whatever. This is the better species. And I am using a lot of sarcasm there. May not be evident. So the husband is using 1 lakh and the wife is using 10,000. You cannot just say, no, she is using it. She is capable of earning her dal chawal. You cannot do that because she is entitled to a lifestyle which was there in the 125 also. She is entitled to a lifestyle commensurate with, similar to the lifestyle that she would have had he lived with the husband. Right? So you cannot just deny because she is employed. You know that, I mean whatever I am saying, my rider is, each one of it. I am only just here to remind the same or just to refresh the same, right? So presumption is an able-bodied man. Many a times the man comes and says, "Hum kuch kaam nahi karte." In Bangla I have heard Bekarachi many times. Many times doing 125, and I am so proud that I worked as a magistrate. I was not a district judge directly, so I had the privilege of seeing the system like from scratch. So he'll come and say, "I don't know anything, I don't do anything." And I look at him, my God, you don't do anything? But you don't look like you have missed even one meal in your life. How come? There are people who will say, "My father provides, I live with my mother. So my father has a small business or a small job, and my mother bears with me and provides me food and all." You can't do that. You won't allow that. If you eat, half of it you have to give to your wife. It may sound harsh to the husbands. I'm so sorry, but this is how it works. If you eat, your wife has to eat also equally. If you travel, your wife has to be able to travel equally. Whatever you wear, whatever lifestyle you maintain, your wife has to be able to maintain that. Many a person, many a OPs that I got in Kalimpong, we are working abroad, Dubai and Switzerland, and they are places that sound to be very rich. I don't know they are or not. I haven't never been to any of these places. So if you are living there, one OP comes and gives me a payslip of 2017 in 2024, and that time he was earning ₹1 lakh per year in Indian currency. And his wife says he is now earning ₹2 lakh per month. He was working abroad in some ship or something. And the husband didn't say anything. I gave him that because it was not a DV Act case even. It was a Hindu Marriage Act case. It was during Divorce Act only that was filed. I raised that presumption, I drew this thing, and I said, yeah, this is the situation, but this is a similar situation. He is not giving, I'm drawing 100 and 106, and I awarded whatever the wife said, on the basis of whatever the wife said he was earning. He kept silent, he was working, he did not produce it. That means you are either earning more than what the wife is saying, or at least what the wife is saying. Had he earned even ₹1 less, he would have produced it. Had he not? So naturally, you have to draw that and you have to do it. Only because you are saying, I am not doing anything, court cannot just let go of it. You are an able-bodied man, you are presumed to be capable of maintaining your wife. Why did you marry? I mean, you have to bear with whatever karma, So, yeah, that is what the law says, and very rightly so. And how would you decide on the quantum of maintenance? These are also, you are all aware of this. Object is to ensure that dependent spouse is not reduced to destitution or vagrancy. So status of the parties is one criteria. Reasonable needs of the wife. Reasonability and dependence you have to ascertain. As I said, your judicial conscience will guide you. Don't be pro-wife or pro-husband. That is the mantra. But Supreme Court itself has said many times, you have to be pro-wife. You have to understand the social strata that we are living in. You have to understand the prejudices and the very idea with which we were born. Like it started even when we were not born. We were not wanted, the sun gives happiness. All of it that starts with the before your birth, that has to be taken in account, and you have to be pro-wife when you are dealing with it. But having said that, you have to understand the reasonableness of the demands. You cannot If the husband is someone working with a salary of 30,000 per month, you cannot probably allow a foreign visit of wife with children every year. You cannot do it. You have to be very reasonable in that. You have to allow only what is reasonable. You cannot be miser for either of them, but you have to be deciding on whether the demands are reasonable and how far is her dependence, right? Cost of litigation you have to avoid, and the cost of litigation in CPC when you die, suit is decreed with cost. You know how the cost is calculated? There's a formula which is like court fee and all. वो कुछ 10-20-30 रुपए में आता होगा वो total cost. Even now, it's very minimal because it only calculates the cost of court fee and those pleading, drafting and all. It's very minimal. But in the cost of litigation when you are doing, I have to tell you, you have to be very pragmatic on that. Because in our country, and I'm afraid in my understanding in any of the country, it is not structured, the payment of advocates is not structured. There are lawyers who ask to pay 1 lakh for one hearing, there are lawyers who will do it for 1,000 and even less, right? So you sit there with you are in a district, we are not working in Supreme Court or High Court, we are working in very basic district. So we understand what are the structures there. So the cost of litigation, if you cannot particularly put it in cost of litigation, put it in compensation. But make sure, because it is very tough. It is very tough. I have had the privilege of interacting with hundreds of litigants in my tenure as a legal service officer, and I'll tell you, one woman comes to me and tells me there were 3 hearings for custody. She had 2 daughters, both of them with her, but the husband was asking for one daughter, not because he was in love, but because he wanted to punish the woman. And there were 3 hearings and the lawyer asked for, I was in Kuch Bihar, there is a district in West Bengal, 8,000 per hearing, and she didn't have 8,000 per hearing, and what order she got? Out of 2 daughters, one will go to husband, one will go to wife, which is a totally illegal order. Supreme Court has said many times, you cannot, the child is already facing the trauma of living with one parent, now he has to live with the trauma of living without siblings. You can't do that. But that was the order, and the lawyer was asking, on top of that, she lost it. At that level she lost it, she went to High Court, eventually she won, but the lawyer was asking 8,000 per hearing, and there were 3 hearings. That girl who was maintaining 2 daughters with lot of difficulty, how could she manage that? If you cannot put it in cost of litigation, make sure you do your calculation, put it in compensation. Make sure you take care of that, because that is a real problem. About legal aid, we will discuss it under protection when we will talk of protection officers, how effective legal aid is. You will tell me in Sikkim, I will tell you how it is in West Bengal. Financial position of parents of aggrieved party will not be of material. What happens very often is the husband will come, see, my father is Tata Birla or Ambani or whatever, but she belongs to that. Her father is a peon. He also earns rupees 20,000, 30,000 per month. She stayed in that kacha house, not even a 1 story, barely a 1 story. So, that is what she is entitled to. Trust me, husbands come and say that. In this 2024 civilized society, husbands come and say that. You don't, that's a Supreme Court clearly said. This is something that I am the most happy about this and that I do. That you do not take into consideration how poor or how rich her parents are. Or they are very rich. They have the capacity of maintaining their daughter. वो हर महीने अपने बेटी को इतना पैसा भेजते हैं. They have put so much in investment. They have even named one house in her name, transferred one house in her name. Any of it, none of it does not absolve the husband of his responsibility to maintain the wife, right? To give whatever is her requirement. It may seem unjudicious, at times you may feel like she has that much of property of her father. Now if it is transferred to her, then you may have to, but if it still belongs to her parents and she is the only daughter, even then you are not to take that into consideration, and that is what on the rules. itself. Independent income and property wife and number of dependents is to be considered. This is one of the criteria. Independent income and property. If the property is transferred to the wife, that is one of the criteria. But and the number of dependents, how many children she has, or she may be having her parents to look after, those you have to take into consideration. This, all of it we are talking of criteria for deciding on the quantum of compensation, maintenance you have to award to the wife, to the aggrieved party. Amount awarded under section 125 is adjustable against amount under section 24. That we have been doing already. 25 in the management. Divorce के time जो होता है वो application में जब हम pending light we give maintenance ना, even at the time of awarding or discussing the decree of prayer for divorce case, we award a maintenance. At the time of decree, we award a maintenance. In case of dismissal we do, but in case of decree we do. So whatever lump sum, whatever we are awarding, whatever it is to be adjusted with 125. That was there. Now this is writing gender sensitive judgments and role of protection officer. These two things we will do in the second half. Tell me whatever you have about the first half. We still have 15 minutes to go. Anything where I or you have any input where I can improve, anything where you think you had a situation, you want some guidance on that, you can please come across. We have not had introduction till now. Yes, ma'am, tell me. I thought it will be a waste of time. Tell me.
My name is Durga. I am CJMs.
So you are the most powerful person. I was told, we used to tell when we were officer, still we do. CJM, even more than the CJM. CJM is the most powerful officer in the industry. With the CM. So you have been dealing with the domestic violence cases, right? How many domestic violence applications are there before you?
Not quite a lot. Actually, I think the cases everywhere. Your women have been very reticent in coming. But now I see a trend because it's been 10 years that I've been a magistrate. And they are more vocal about their rights now. So I see more cases coming up. But I'm sure the percentage should be higher. Should of course be higher. And one of my experiences has been that police is very, in spite of what perception is a thing, we still have some amount of patriarchal mindset. And I've seen that in police where they're very reticent in taking up domestic violence issues. It's like husband-wife matter. You said
absolutely. That's how it is everywhere.
But in the course of 10 years, I've seen a change where women are coming out. Most of the time, there's stigma, shame, all of that is
we have to appear to be very happily married person. Somehow we add that to our array of qualifications. Are you happily married? Well, I have not been. And if I say that, it is perceived primarily as a disqualification of me being a good woman. I'm not a good woman. Had I been a good woman, my husband would have loved me and I would have had a very secure and safe household. I mean, that is a very fallacious idea with which we live. So we try to prevent that, we try to camouflage, putting a lot of makeup to hide the marks of injury, if any, on the face. Thank you, ma'am, for your input. Yes, ma'am.
My name is Rohini Rai and presently posted Judicial Magistrate.
Good. And what about you? How many are you dealing with DVAC cases right now?
Yeah. I'm not exactly sure how many cases are there, but I think about 30 to 50.
Oh, that's quite a good number. That's quite a good number for Kalimpong, for Gangtok. I keep going back to your neighbor's place. But by the fact that you are the magistrate and the chief judicial magistrate also may be having, and so that distribution is quite a good number, right? And you think it is the orders are executed well?
Yes, ma'am.
The police and protection officers, are they doing their job?
Yes, they are doing it.
They are doing their job. You happy?
Yes, I am, because in most of the cases, the parties are prefer to settle the matter.
Oh, that's good. So is there any way, I'm not talking of DVR, we are talking of just two officers here. Is there any way you follow up the protection officer sends report, or you continue with the file after compromise? You don't. So do you refer it to mediation or DLSA for a follow up?
Yes, ma'am. At least once we try to take the matter to mediation.
So please think about it, just going by whatever we discussed right now. May I have your attention now? So please do think about it. If it is possible, the compromise things are done under duress, mostly. It is very difficult when one party, especially wife, goes to court and then everything ends up happy and hunky-dory. It is difficult idea to proceed, but what you can do is when there is a compromise, we close the record. We have no means of continuing it. Compromise decree closed, case disposed of. Please think about it. I was just thinking, only by going by your input, that if we can refer it to the DLSA, and there is a means where we can have an annual or monthly or a periodical report through the protection officer. Keeping a tab on. Think about it. I don't know. I have not done ever, but I hope there is some kind of a mechanism where you can be of use to you as a system can be of use to the victim. The protection officer can do that, I think. So then there is a fresh DB Act application.
It becomes a
Comes for execution of the compromise order. That can be done, of course. Protection order, then there is a criminal thing. Then this complaint is filed. Right. That was really good. Yes, sir.
My name is Javian Sharma.
Sir.
I am posted as CJM Ranchi.
Oh, Namchi, that famous temple. I have been there now. How many DB Acts you have, sir?
Right now I have only, I think, 2 cases.
Only?
I have
That's very
done
good.
about 10, 11.
That's good. Now that's good. Having said that, there are 2 aspects of it. One, there is a less number of violations, and 2, more importantly, as the CJM Gangtok said, the resistance and the hesitation and coming to court. If that be so, the DLSA secretary of your district, is there any, or you are serving as? You are serving as the secretary DLSA? Okay. So the DLSA secretary may hold awareness programs about DV Act, because mostly women do not come out. They do not know. This law was enacted in like 19 years back and was notified also long ago, but they do not know कि कहीं रहने की जगह नहीं. So they are afraid if I go out, I will be rendered homeless. So this is something for which awareness is required, right? You can please do that, especially in Namchi if you do it, because there are very little number of, and I'm sure there cannot be, it cannot be that you are a gentleman so all the people in Namchi are gentlemen. I don't believe that, right? So we have to create a situation where they are comfortable in coming out and lodging complaints, right?
Yes.
Yes, thank you, sir. Yes, madam.
Good morning, ma'am. My name is Mahima Rai. I recently assumed charge as Judicial Magistrate in Wrongly subdivision, and I have only one DB as of now, but that is also one for mediation. But ma'am, what has happened is, before me, my predecessor, she had given this protection order where she had ordered 20,000 maintenance, and then the opposite party, he filed for modification because he said so and so has happened and I cannot pay. But when I saw that nothing has changed, there was no change in circumstances, and I upheld the order. I said I'm not going to modify anything. Then I also said that you need to pay the arrears since no payment has been made. But now what he's saying is I've appealed, so I'm not going to pay. What do I do?
No. Tendency of appeal does not imply there is a stay. There is no stay. Has the appeal court stayed?
No.
No. So So your record is, now you have rejected the prayer for modification. Until there is a stay in Calcutta High Court on both judicial and administrative side, there is an order, and administrative side also, that without stay you do not allow any time. There has been an instance, Honorable Lordship will be able to help you with that. When Honorable Chief Justice Sikkim was Honorable Acting Chief Justice Calcutta High Court also, and there has been situation when Honorable Calcutta High Court on administrative side show cause one judicial officer only because he adjourned a matter on the ground of pendency before appeal court without any order of stay. You cannot do that. By adjournment, I also mean delaying or not complying the direction here. Had it been an execution of a, say, vacation order, recovery of possession order, then you have to wait for all practical purpose, because you cannot, dispose somebody till a decree is upheld or set aside by honorable court. But when there's a maintenance thing, you have to ensure and you have to start proceeding. See, I had this thing, I'll just take you back. We were discussing some difficulties and I told you that in very few cases the magistrate suo motu does something. Did I? I did tell you, where was that? I have to find out. See, execution of orders, I told you, there are very few instances of such suo motu exercise of power by magistrate. Use it. Use it, madam, right? Go back to office. The next thing you do is direct put up of the record and start process for execution of that record. The only justification of that order would be that honorable court has pleased not to stay. Honorable court has pleased not to stay. What do you think? They have not moved the stay application before honorable court. The first thing at the time of filing the appeal is, or you can check the CIS also and you will get the order of honorable court. If there is no stay order, even if the stay application was taken up for hearing by honorable court on the first day, that means there was resistance on the part of honorable court. There was reluctance. And moreover, this is for survival of the wife. This is important and urgent. वो भूखी रहेगी क्या उतने दिन? The very basic question you have to ask. When you write the order, you know how to write the orders. I am not here to tell you that. Your justification in writing the order should very well be there. You are not doing something to somehow undermine the authority of the honorable court or of the appellate forum. No. Your justification is that honorable appellate forum has chosen not to stay. That means you are duty bound to get its execution done, right? So don't allow it on that. We have this. Oh, अच्छा time हो गया क्या? Before time खाना आ रहा है. अच्छा, thank you, ma'am. So you have to start the execution proceeding, and you don't wait for this because they do that. After filing, there is a. Okay, we will do it after tea. Yes, sir. Let us finish the.
Good morning, ma'am. I am Sikkim Sutta, posted as Judicial Magistrate Yanya and Judicial Magistrate in charge Ranchi.
And Secretary
Secretary in charge DLSA.
Secretary in charge DLSA also. You have a lot on your shoulders and you have to do a lot actually. I totally believe that for everything, especially DB Act, especially the holistic act that we have, the role of DLSA is like it increases manifold, right? So we will take up from here after tea. Madam, I did not. Yeah, I'm so sorry. Yeah, please.
Good morning, ma'am. Myself, Sonam Bhutia. I am Center Administrator, One Step Center, Mangan. Ma'am, recently our protection officer resigned from her post, so I have been
nominated. Are you also acting as a protection officer?
How I have to?
You have to, because that post cannot be left vacant.
Yes,
It's very important nowadays. Right?
Yes, ma'am.
So you are acting as a protection officer for Gangtok?
No, ma'am. For ma'am, Mangan.
Mangan.
Yes.
Mangan is represented by you, sir?
No,
that is not here. So you are in charge of Mangan. Okay. So there are quite a few vacant courts also, like every single officer is manning 2-3 places. So for your whatever cases you have, madam is working as a protection officer. So thank you, ma'am. Ma'am, your mic is not open. Yeah. Why it's not working? Please see, gentlemen, the mic is not working. Yes, ma'am, you ठीक करिए उसको. नहीं, फिर बंद हो गया, दिख रहा है. See, there's a light. Yeah, now it's working. In North Sikkim?
There's not a single case on the close trial.
That's good. Again, you have to seek the help of the officer who's working as a DLSA secretary.
I'm in charge.
So if you are in charge, you have to plan and take up, programs for awareness on DV Act. It's very much required. FOXO and DV Act.
In all awareness programs, we make sure that we include the topic of domestic.
You have, okay, well, let us finish chai. Thank you, ma'am. Then thereafter we'll take up. There are 2-3 aspects of this whole issue. One, it is not reported, and 2, we lack infrastructure. It is in the process. We do not lack. In Sikkim we do not lack, but we are in the process where the infrastructure things are coming up. The shelter homes and all the one-stop centers and the medical facilities and all of it. The first part, the infrastructural part is to be taken care of by state. So we as judicial officers do not have much to say, and fortunately in Sikkim you are in a state which is like, you are literally living in heaven. Trust me. Because you have not lived in West Bengal or Bihar or Jharkhand or Odisha or whichever, any other state of West Bengal. You have a structure where the government is not at loggerheads with the judiciary or with the people, and there's a holistic approach and things are improving. I'm told the relationship between the High Court and the government and all these are also very harmonious, which is very, very healthy. Now, why do women don't come to complain? Why do we lack? What do we lack? One, the knowledge that this law is there or such provisions are there. Only telling them there's a domestic violence act would be of no consequence. Even I don't know what is a domestic violence act. First, create books, the DLSA, create books in local language. Very small leaflets. You have the fund, and Honorable Chairperson and Honorable Patron-in-Chief, I can say about Honorable Patron-in-Chief because I've seen Lordship's work as a Chairperson of State Legal Services Authority. How proactive can it get? You get small booklets, not booklets, just 1 or 2 pages. If you make it big, nobody, even I don't read a thick book. So you make it 1 or 2 pages. What is a domestic violence act? Don't write Ghaluli inside. Just write it. If you are beaten at home, if your money is taken up by your husband or anybody for alcohol or whatever, if you are deprived of this and that, there is a law which will ensure that you can stay in that home and your shelter and food is ensured. Only you have to call this number. You can start learning secretary in charge, DLSA. You can start a helpline number only for dedicated to domestic violence and POXO cases. You can do it because I really wish I was in Sikkim. The circumstances were so congenial to work. And trust me, it is far more satisfying than the SNJPC work. You know what is SNJPC? The second National Judicial Pay Commission order. Right? A huge salary, all the perks, all the allowances. If you can do this, if you can start a helpline and you can follow up with these numbers you got and you could help one person, trust me, you've been helping one person is so satisfying. लगेगा जीवन धन्य हो गया. वो सैलरी से नहीं लगता जो हर महीने आती है और पता नहीं कहीं चली जाती है, रहती नहीं, बैंक में रहती है और फिर हम चले जाते हैं शमशान को और फिर वो सैलरी पता नहीं किसके पास जाती है और कहाँ कौन करते हैं, पता नहीं चलता है. कोई लेकर तो जाते हैं साथ. दिस इज नॉट, आई एम नॉट टॉकिंग ऑफ धर्म, आई एम टॉकिंग ऑफ वेरी बेसिक थिंग दैट आई थिंक ऑफ एवरी डे. बट द satisfaction that you get by doing the work, especially under DLSA, it's something that really nourishes your soul. Trust me, it does. So for domestic violence, create small booklets in your local language. Make sure it is distributed to every single woman. Make use of schools. Make use of, motivate the teachers. Because as we were discussing, in domestic violence incidents, it ought to affect the child. The child's performance comes down, his behavior, his, a very happy, healthy, smiling child will come to school one day morosed. If the teacher is motivated enough, he or she is the first point of contact for them to discuss, or even discuss with other children in class who may be motivated by the teacher to discuss these things and to normalize these discussions. This is normal. This is not something to be ashamed of, right? So those things you can do as DLSA, motivate the children, because even in villages children are coming to school, that the right to education thing has worked well. In Sikkim I've heard. So you can do that. We can have, in Namchi there are not only 2 incidents of domestic violence that I can vouch for. We are ready to reach. वो जब situation आएगा civilization का, we will not have courts. We are all going to lose our jobs, right? And I'll be very happy. So start doing that, please. That's my request. That's not part of my curriculum, but that's my request. Now we are to go to the roles and responsibilities of these things we have done. Of protection officers, I am told. Execution of orders we have done. Do we need to discuss more on execution of orders? Is there any difficulty on execution of orders? Section 32 you have to invoke. If there is a criminal breach, you will proceed with as per the criminal law. CRPC will come in play. If there is a civil breach, you will do whatever you have to do. You need me to discuss it? Fine. So then we have to go back to the execution part. Penalty for breach is there. Execution of orders, execution and penalty, that is all the same. Execution general principles, violation of protection orders under subdivision 6, complaint case under 498 can be lodged by invoking provisions of CRPC. Police may be compelled. The officer in charge is to see. The officer in charge, role of officer in charge has been repeatedly reiterated in the Act. The protection order copy, also the protection officer is to give to the officer in charge. You know about that. So, that is there. And about the civil breach, there is no civil breach. There is a breach of order of residence, it becomes criminal. Once there is a breach, it becomes criminal. And once it becomes criminal, the officer in charge and all the police will come in force. The police will see that it is enforced, it is executed. Like the person disposes will be put in position again. You understand? When there is a civil suit, there is an order suppressing a domestic violence order. The daughter-in-law doesn't even know and the father-in-law gets an eviction order. May happen, right? The daughter-in-law may not know, she is not even a party, and an eviction order is passed. The father-in-law gets that. Right? You can send the protection order, the residence order to the officer in charge to make sure. Because it was not done, the eviction, the disposition has to be done by due process of law. It was not done by following due process of law because there was a suppression of fact, right? So those are things you can explore. Penalty for breach we have already discussed. This whole slides will be, this thing, PPT will be there. You can go through it once again. Now we are coming to that I will do this one also. First we will discuss the protection officer. And then I'll come to this thing. Protection officer. Because that is one of the role and responsibilities of the protection officer under the PVD, Protection of Women from Domestic Violence Act, right? So, Rule 8, rather Rule 4, starting, you must be having a copy of the Protection of Women from Domestic Violence Rules of 2006. Are you having a copy of the rules? Right? So, actually the duties of protection officer starts from Rule 4. Although technically that is there under Rule 8, 9, but from Rule 4 only it starts. Information to protection officer. The protection officer has to be informed, and the protection officer under Rule 4 when it is informed, the protection officer shall prepare a domestic information incident report. Now, under DV Act, it is not mandatory for the magistrate to call for a DIR. It is not mandatory. The magistrate may call for, right? But when it comes to the protection officer, he receives the complaint or the information. Section Rule 5 says he shall prepare a domestic incident report. There it becomes mandatory. And he has to place it before the magistrate. Let me share something here. In my understanding, protection officer has a humongous responsibility under this act. सब कुछ protection officer को करना है. I wish there were more protection officers here. We have magistrates, but we could have. Are there other protection officers in other districts in Sikkim? There are. So they should have been here. It would have helped us to understand how things are working here and what difficulties they are facing. The protection officer first, he can be the first point of contact. In DV Act, he can be the first point of contact. Even somebody who does not want to go to police or does not want to go to court, a protection officer will do literally everything. He will write the complaint, he will give her the format and help her write, or he may write it on her behalf as per her instruction. He will have to provide for their medical treatment of the victim, her child, whosoever were affected. He will have to provide for the transportation. उनको घर से हॉस्पिटल तक ले जाना है, वो व्यवस्था that protection officer will do. You understand the huge responsibility of the protection officer under the act? I will dare say it is more than the magistrate. It is even more than the magistrate. Magistrate will not take the victim to hospital. The protection officer will. Or you have to take the victim to hospital even before a judicial order is passed by the magistrate. Yes, of course. उसको ऑन करिए ना माइक को. सर जरा माइक ऑन करिए.
Ma'am, there is a one-stop center in each district. Once reported the domestic violence cases, one-stop center used to take the victim to the hospital, everything like medical assistance provided by the one-stop center itself, ma'am.
That's very good. That's awesome. So one-stop center तक आप ले जाइए.
Yes, ma'am.
You understand?
Yes.
So you are the first point of contact. But when that's why I said I wish I was. You have one-stop center everywhere.
Yes, ma'am.
If you have, then you are the one. See, you have to inform even the magistrates that there is a one-stop center. And that's not what I am saying. That's what the rule says.
Yes.
You have the responsibility of informing the victim. And not only informing, executing that information. You have to take her or facilitate her transport from her house or wherever she is on the road to the one-stop center or to the medical facility if there is no one-stop center, as the case may be. You will do that. You will ensure that the medical place, the hospital, private hospital, the clinic, a private doctor, provides free medical treatment to her.
Yes, ma'am. There is.
ये आपको करना है. Now it is huge. I cannot imagine that in Kolkata. I cannot imagine that. Because it is not like you have a government hospital everywhere. When there is a densely populated big place, there are very few government hospitals and BPSs, very few. Like if you need 100, you have around 2. That is the proportion of availability and demand. So what you do is, yes sir?
I just asked a what is the salary as a protection officer. She is getting me 500 rupees.
5,000.
5,000.
See, that is what, we put so much on somebody without giving anything to them. That is an infrastructural problem, sir. We as judicial officers, we only have a pen. There was a time when for pen we have to write an application, but I may be provided 2 dot pens, one blue and one red. I remember writing that. You know, I was a magistrate when you were not born, literally. So there was a time we had to write that. The problem with us is, and it is not a problem with DV Act only, in our system we have amazing legislation. Abhi when we are discussing a lot about a very unfortunate incident of Kolkata, people are asking for stringent laws. I strongly disagree on record. We have amazing laws. Where we falter is execution. Where we falter is execution for 2 reasons. I wrote in one of my judgments in Kalimpong in the month of July 2024. Either we lack knowledge or we lack willingness. It was about a police person that I wrote it, but it applies very much to almost all of us, all service providers, all stakeholders. The problem is of execution, and that is for 2 reasons: lack of knowledge or lack of willingness. And willingness comes with a lot of things. Your willingness is related with your salary also, believe it or not. You don't expect somebody, and that has been discussed by Honorable Supreme Court in Shetty Commission report, in Second National Judicial Pay Commission report, in Marimat Committee report where they discussed police's actions. It is discussed in detail that for somebody to act well, if you expect a good performance, you at least make sure that their children are well fed. You can't pay 5,000 and expect them to be awesome, because they have to be bothered. No? It is not about being materialistic. It is about the very basic fact that if I am burdened with the fact that who will take my child to school because I cannot afford a school bus or a car to ferry him, I cannot put my mind totally, my soul into the work. I have to take care of that also. The system has to take care of my responsibility, my very basic demands of my life, so as to free me to be able to dedicate myself totally to the job at hand. That's very basic. This is not my thought. This is very basic. We are facing every day. This is very basic that has been discussed by Honorable Supreme Court and Honorable. Many Law Commission reports are there on this. You can go through it and you will find it. Right? So you cannot expect a protection officer to work awesome with 5,000. Having said that, it is not necessary with a 5 की जगह 50 कर दो तो वो awesome काम करेगा. नहीं, but आपको motivation का part है वो भी. That is also there. So the very apt question that you asked, gentlemen, that what is the salary that they are paying to the protection officer? They are not. That is not adequate at all.
Madam, may I? Madam?
Yes, please.
There was a practical difficulty that we were facing at Ranchi. That is, in most of the DV cases, a big person needs urgent interim relief. So in that case, due to maybe sometimes unavailability of protection officers, they were not able to get appropriate relief on time.
Right.
And for applying for legal services also, there is a process and that takes some time. So that was the difficulty. So this was because of unaware on my part about
No, I
the duty
understand.
of protection
No.
officer.
We are all unaware. We are all struggling to learn, sir. And don't hesitate ever to ask questions. I ask so many questions that the judges there are so petrified in saying we should start asking questions. So that's okay. That's very much okay. Now the point is, the law says there has to be protection officers. The appointment of protection officers is not in the hand of judicial officers. It is for the state, right? Now whether there are situations where you can do away with protection officer, for a magistrate when he receives the complaint, the law does not mandate having protection officers report. But there are certain functions that are laid on the protection officer and the protection officer has to exercise that. What you can do, sir, don't use the word protection officer, but you can, again as I told Rai madam a little while ago, be logical and judicious in your orders and you write orders. What you can do is, as a magistrate you are sitting and there is no protection officer and you have some work for the protection officer that has to be done. You can invoke your power under the DV Act which says you can use procedures as per your choice. You can ask DLSA. You can ask DLSA to write to the district magistrate. You can write to the district magistrate as magistrate that there is no protection officer. Look here, you please assign somebody to do this. A social welfare officer that is there in every district. They have. There are DM office के structure में है. अभी हाँ 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 as protection officers, madam?
Not as protection officers, but they used to do all the duties of.
So they can fill in. They can fill it provided there is a DM's order.
They were appointed by
उसमें
by the state to the service authority.
yeah, SLSA can do that, but appointment of protection officers is not SLSA's prerogative, right?
What she's trying to say is the legal retainers are filling the gap.
I understand that. I get that totally. I totally get that. But to make it official, you know what? There are certain jobs assigned to protection officer. Some you have a PN, you have a volunteer, you have a social work officer. So that's why it said write to the DM that please assign the responsibility of a protection officer on any competent officer. And you must be having a district judge, right? I believe you have means of communicating. If you don't have, request the CJM, respective Chief Judicial Magistrate. They can have a direct communication with the district judge. There are periodical meetings between district magistrates and district judges. Administrative side के लिए, it is there. That structure is there in different forms in different states. So the district judge can take it up with the district magistrate. First you have to write order. Thing has to start from there. आप एक district magistrate को order कर रहे हैं कि there is no protection officer and these are the things. You write an order first कि protection officer का आपको एक report चाहिए कि कितने वहाँ family members हैं, कितना income है, actual incidents क्या है, medical report का collection, whatever you want from the protection officer, right? You write that and then you can write that it is informed that there is no protection officer, right? And so that you send a copy to the DLSA and to the district magistrate, right? Wait for the response and you discuss it orally because we cannot send order sheet to our superior courts. I mean that's the hierarchy that we are practicing everywhere in India, I believe. You discuss it bring it to the notice of the Chief Judicial Magistrate. Said, ma'am, this is the situation. I have written this and that. So what they or he or she will do is they can bring it to the notice of the district judge so that it can be brought to the notice of the district magistrate, and this is not a long run process. What I am telling you now ऐसा लग रहा होगा इसमें तो एक साल लग जाएगा, इसमें एक साल नहीं, इसमें एक दिन में भी हो सकता है क्योंकि आपका ऑर्डर शीट जा रहा है और वहाँ आप लीगल प्रोविजन मेंशन कर रहे हैं कि these are my requirements to be able to adjudicate on DV Act, these are my requirements and these requirements are to be addressed by a protection officer as per such and such provision of DV Act. As there is no protection officer available here, so I am bringing it to the notice of the district magistrate with a request. You should be very cautious and we will be coming there. You should be very cautious in your choice of words when you are writing the orders. Like I never write directed to. Even if it is an officer much below my rank in the hierarchy, I never write directed to. I write requested to. It does not make any difference. The message is going. See, if I am telling you, madam, please don't talk. I am literally telling you, don't talk. Right? The point is, you make yourself clear, but you make yourself clear in a way which is more acceptable to the person who is receiving it. Don't get arrogant feeling that I have the pen and I can write the order and I can write personal appearances. Don't do that. I don't. I mean, see, look here. Whatever part of my discourse or my statement to you seems unacceptable to you, go out and there's a dustbin and throw it there. Bring it out from here, throw it. I don't mind. Not at all. But I have to be, in all honesty, sharing the good practices that I have used with awesome effect in my life. My district magistrate kept my chamber with a small book and gift, when I was transferred out. This is unthinkable in West Bengal. The point is, you create an impression of judiciary. You don't create an impression of Madam such and such, sir such and such. You create an impression of judiciary. You are a flag bearer of judiciary. Your language, your demeanor with any person of any other office, of course your own to him, should reflect education, not arrogance, right? So you can very, in all humility, you can write to the district magistrate requesting him to look into the matter or to assign any other officer having experience of social work to deliver this responsibility. He can, because the responsibility of state. Yes, ma'am.
We have a lot of women from Sikkim. Sometimes we get married to like men from outside of the state. But because women have the privilege to file like cases at their place of residence,
No.
most of the time they come back to their father's, mother's home. So
Yeah.
they file cases. So in this case, how do we file?
See, this jurisdiction thing, we will discuss this jurisdiction thing. Give me a minute. We will discuss this jurisdiction thing. I do not agree with you fully that they have to come back to their house to file it. I will address it with the decision of Honorable Court I have, right?
It becomes easier for them because they have the support. So they come back to the parents' place.
True.
They have all the financial and emotional support to file cases here.
True.
Because they are already facing violence over there.
Right.
And
There's a hostile situation there.
Yes.
Madam, there are two aspects to it. One, that as you rightly said, that it is comfortable for them to come here to stay with the parents and brothers and sisters and whatever and lodge the complaint, तो हमको पूरा support मिलेगा. But there's another part to look at. When we lodge complaint, state-wise we have a very, very poor interstate, intrastate communication so far as policing is concerned, so far as courts are concerned. Now these are areas I'm so happy that I came here, not only because I had awesome hospitality and could visit Baba Mandir yesterday, that was really the cherry on the cake, but because we need lot more interaction amongst states. हमारे यहाँ वारंट एग्जीक्यूट नहीं होते क्योंकि आसामी सिक्किम भाग गए, नेपाल भाग गए. I had a meeting with the Superintendent of Police a few months back while I was in. My reference to Kalimpong is not going to stop ever. It was such an awesome place I worked in. That the WAs and WPAs cannot be executed because they go to Sikkim and they are sending. They told us, and one of the officers in his good senses, God help him, send warrants to say officer in charge Namchi. I don't know whether Namchi is a police station or not. The kind of officer in charge Gangtok. And I said, you can't do that. You can't do that. I cannot. I mean, I can issue WA address to the police station from where the case originated. That's what the CRPC message is. And they have to take it. Suppose एक आसामी भाग के दुबई चला गया या दिल्ली चला गया. I cannot issue a warrant addressed to the officer in charge Delhi police station, whatever police station. I have to address it only to the officer in charge who is in charge of that particular case from where it originated as court. And that police station officer in charge or the person who is in charge of executing that warrant or WPA whatever, they have to take it to the other state. They have to requisition their help. This is their internal mechanism. Court has no place to role to play here, right? Similarly, in a DV Act case, if somebody comes to you, her husband or the OP is residing in Delhi or Mumbai or whatever place, for you to get it executed will be a very, very difficult situation now. That's a practical thing. It is not written in DV Act or rules. Law will say, CRPC will say, आसामी कहीं भी जाए पुलिस जाके, even पुलिस रूल बुक PRB will say, आसामी कहीं भी जाए पुलिस जाके पकड़ के लाएगी. I have had executing officers coming to me telling, madam, somebody came and complained कि उन्होंने उसके लिए 20,000 रुपए मांगे. दिल्ली में उसको आसामी उसको पकड़ के लाने के लिए पुलिस ने 20,000 रुपए मांगे. I called the person, भैया क्या बात, सैलरी नहीं मिल रही. मैम वो टिकट काट के 3 लोगों को वहां जाना आना पड़ेगा, वो टिकट के पैसे हमको कौन देगा? You understand? If there's a VIP accused or a VIP complainant, these are unfortunate situations, madam. We have to face it, but we have to find out ways and means of doing it. कैसे करेंगे, कैसे नहीं करेंगे, वहाँ के DLSA को खबर दीजिए. Legal services can be very useful. I'm telling you, it looks useless on face because they are not putting anybody to किसी को फांसी पे नहीं चढ़ा रहे, जेल नहीं भेज रहे, लेकिन they can be very useful. Like all the online video conference में जो गवाही होती है, everything I have used DLSA like anything. Dehradun DLSA has been of lot of help. Allahabad DLSA has been of lot of help. You write to them, there's a WA pending, there's a DVA case, please help us execute it. This and this DS is there, and you may get lucky. And I'm saying you may get lucky. The premise is mostly you will not, but you may get lucky. And you have to take your chances, because jurisdictionally you can, I'll come to that, but practically for execution when it is required, it is difficult. Take help of other agencies. Our rules are very limited so far as inter and intra-state executions are concerned. There are very, very little rules there. कहीं नहीं लिखा है किसी भी कानून में, आप मेरे से पूछ लो, मैं बैठ के कहीं भी बोल दूंगी. नहीं लिखा है कि एक स्टेट से ओरिजिनेट किया है, कैलिम्पोंग का WA है तो नामची या गैंगटॉक का OC जो है वो मैंडेटेड है एग्जीक्यूशन करने के लिए, और नहीं करेगा तो it will be similar amount of contempt. You understand? There's a lot of red tapeism here, if I can use that word. But we as judges, we have to break free of that. How we do it, we'll have to sit down and work on it. You have to be very, you have to evolve your ways and means, and there is no better place than DVA. आप simply वो provision बोल देना. अगर कोई पूछे कल को आके, कोई डिस्ट्रिक्ट जज से दिल्ली से आके बोले ये ऑर्डर कैसे किया आपने, हाउ डिड यू पास दिस ऑर्डर, यू जस्ट राइट दैट इन योर ऑर्डर शीट. Under such and such rule, the law says the magistrate can evolve and NB says his own procedure, and there was no other procedure. Write in your order sheet. Order is clearly लिखना, कहानी जैसे लिखना, पढ़ के समझ में आए किस सिचुएशन में आपको वो लिखना पड़ा. Whether it is the requesting the DM, whether it is requesting the officer in charge of some other district. Send that order sheet through the district judge of that place. रिक्वेस्ट करके एक रिक्वेस्ट ऑर्डर ऊपर से कवरिंग करना, ऐसे मत भेज देना टू द डिस्ट्रिक्ट जज फॉर एग्जीक्यूशन. Don't do that. All of us have our छोटा छोटा egos, and we have to respect it, right? उसमें कवरिंग लेटर करना, रिक्वेस्ट करना कि OP is, because the OP is living in your jurisdiction and we have no other means of, so I have requested the officer in charge of such and such police station to get it executed too, because that address is within your territory. So I am seeking your kind help. You have to be very proactive. You have to be very, your imagination should be very strong, but you have to make it work. You can't say the law doesn't say. The buck stops at you. You are not at liberty to say the law does not say. क्या करें हम? हमने local PS को बोला, वो तो हाथ उठा दिया, उसको भी कुछ करने का नहीं. But you have to get it. Do it. Go on. You will get the result. So I have that. About jurisdiction, I have certain judgments. I will tell you about jurisdiction, right? First, let us adhere to the syllabus. Syllabus complete करना है ना? Role of protection officers. It will start with Rule 4. Rule 5, the protection officer shall prepare the report, shall produce it before the magistrate, and before that he will take the victim to the medical help, whatever is required, right? And then he will request the service provider. Like Madam said, there is a one-stop center. You can take it to the one-stop center. The service providers, whatever they are there in the rooms, there are social workers, there are medical persons, there may be schools involved when a child is involved. You have to request the school that बच्चा 3 दिन वहाँ जाके शेल्टर होम में रहेगा तो स्कूल नहीं आ सकेगा, तो आप उसकी एब्सेंस को काउंट नहीं करना. वो सारा प्रोटेक्शन ऑफिसर करेंगे. जितने भी लोग इन्वॉल्व हैं, all the stakeholders, you are the glue, you are the connecting thread. वो माला के सारे मोती को मिला के आपको बनाना है एक्चुअल. और ये इतना सारा रिस्पॉन्सिबिलिटी है और वो उतनी कम सैलरी है, सर ने बताया, बट करना तो है. मैंने सैलरी का बहाना नहीं ले सकते क्योंकि आप और मेरे जैसी ही कोई महिला है जो वहाँ बैठी. You know about when saying this, I have to tell you, while growing up we did not know. While growing up we came across domestic violence in every shape and manner. Each one of us, except maybe a few fortunate who have not seen it in their homes or neighborhoods or sisters-in-laws or brothers, whatever. All of us have seen. We do not like to talk about that. We talk about survivors as they, not as we, because that puts us in a higher pedestal and make us, we are civilized. No, we are not. No, we are not. And we have to do every little thing that comes to us with the belief that each one of us has been or will be exposed to this in some manner. We are mothers, we are daughters. Come on now. We cannot forgive that. We cannot forget that fact and forgive any dereliction, any deviation, right? So, notwithstanding the salary, good or bad, we have to take care of each complaint, right? So, you have to connect to all the service providers. You have to make application. You have to make the client, the AP, aware of all the legal aid provisions. आपको उनको DLS सेक्रेटरी के पास भी ले जाना है, एक अच्छा देख के. Now a good lawyer is a misnomer. Forgive me, but my experience is among legal aid help, quality legal aid help and honest legal help, which is more required than quality. Honesty will bring you quality, but quality will not ensure honesty, right? If you have honest intentions, you can procure quality. So to provide them honest legal help is a huge challenge for DLSA as well as for protection officer. Magistrates तो कुछ कर नहीं सकते, lawyers argue भी नहीं करते हैं सही से जब legal aid मामला होता है. You have to write for a change sometimes, even that is not perceived well, and there is a resolution and there is a difficulty in exercising and disposing of your work. Those are human issues and we have to deal it with lot of humanity and lot of diplomatic sensitivity, right? Legal aid आपको बताना है उनको, assist करना है complaint डालने में, and there is rule 8 and onwards, lot of responsibilities you have, including appointment of counselors. The protection officers has a huge role in appointing of counselors. I don't know how they expect that for 5,000, but that is a huge responsibility. You have to identify proper people who can work as a counselor. Counselor जो है, restoration of a healthy mindset. Mental health is a big issue for a domestic violence survivor, the child, the wife. So you have to assign that also. You have to select the counselors and you have to assign a counselor also. Literally you are the one-stop center. One-stop तो बाद में आएगा, right? One-stop center आप ही हो. You have to inform the police when there is an interim order or the final order and they are not complying. Even when initially जब आप उसको वापस put in possession करते हो, even before going to the magistrate, even when there is no judicial order, even at that stage you have a responsibility of assuring that she is placed back in possession. कैसे करोगे? I don't know. The rule is silent. This is with the help of police. Why will police hear you? Police will ask, who are you? You say protection officer. Police will say, what protection officer? Because they don't know. They don't know what a protection officer is, and the responsibility again comes back to the DLSA to inform all police officers with a list of protection officers who are there. Have you provided that to all police stations? A list of protection officers under DB Act? You have? You have? And with the phone numbers, and all the protection officers have to be provided with all the phone numbers of all the police persons working in the area, especially in hills, because the community is so tough. All the medical officers, the kinder ones who are able to, help even at odd hours, it is very unlikely that दोपहर को 12 बजे आपके पास victim आएगी. It's more likely that she will come to it at 12 a.m. or mid of the night, right? So at odd hours you have to have help. You have to be armed with all the phone numbers and all the connections, right? अगर वो ना माने तो DLSA secretary का number भी आपको रखना है. Do you have an order? In our times, Honorable the Chief Justice of Sikkim High Court, as his lordship then was the chairperson of the State Legal Services Authority, there was an order for all district legal services secretaries to pick up their phones at any hour, and if there was any missed call, there was a show cause. Know that? Know it? You better know it, right? Because you are made as an emergency service. The protection officer can call you, a medical officer can call you, a victim can call you directly, right? So I'm not here to आपको डराने के लिए नहीं बोल रहा हूँ, but that's true actually. That's part of the package, part of the job that we are doing, right? So why will police hear you? Because there is an information and they are aware that they are bound to under the law, under the rules of DB Act, which are framed under the law, that they have to comply with the information furnished by the protection officer as much as that of the magistrate, right? तो आपको वो भी देखना है कि पुलिस ऑफिसर उसको engage करे, उसको execute करे. आपको immediate help of police भी you have to seek as under Rule 9, sorry. Now, Rule 10 also puts certain other responsibilities, certain other duties on you. No, it is not there. You are looking at the screen, it is there, but I am not looking at the screen, it is there. ये सारा आप देखते रहिएगा, मैं यहाँ से कर रही हूँ. You have to record and maintain all the copies and everything. I'm not good when I'm reading, I'm better when I'm writing and I'm speaking often because I've read it all. So, whatever help is required, we will provide that. You have to liaise between the aggrieved person, police, service providers in every manner that is provided under the Act, and in every situation that you believe that at that time is required, even if it is beyond that, right? You have to maintain all the records, as I said, phone numbers, contacts and everything. Okay, sorry, right. So these are pretty much the rule of the protection officers. Even service of notice protection officers has a role, right? And for the magistrates, I'll just come back for a while that you can use CRPC, you can use CPC in issuance of notice, even order 5 Rule 20, everything you can do. You can serve notices through publication in newspapers, you can serve notices through email, right? Like now amended rules and everything you can do as a civil court, like pasting of notices and all you can do under the DB Act also. Like that is it. And the protection officer, you have one more thing to do. Suppose there is a restraining order that the OP will not visit or will not meet the AP for such and such period or such and such whatever. There is a standing order passed by the CJM or the JM. Now the AP makes a call or writes or whatever and asks the OP to visit and they are in love again for the time being or whatever. That is illegal, we cannot. You have to prevent that. You say क्या अच्छा हो रहा है, मिट रहा है सब, दोस्ती हो रही है, आप उसको भी रोकने को बोल रहे हो? Yes. The law says you have to ensure that they go to approach the magistrate for modification of the order before the parties meet or before the restraining order is done away with by any of the parties. Even the AP is not at liberty to do that, right? They cannot be like, okay, Mia Bibi Razi, you can do. No. The law is very clear on that because there are situations, the APs are very, very vulnerable, we have to understand. One phone call by the OP and the APs will be all, flowed, and will say, okay, all has ended, let us be together. No, you can't do that. You have to have interference of court, and that is one part that the protection officer will ensure, will see that it is done, right? So you will also actually supervise the actions of the control of the counsellors, of the service providers, of the workshop centers, whatever you have. You are the one who will see that these are acting, working properly, and any deviation is reported to the magistrate or to the district magistrate as the case may be. That is also duty of the protection officer. And the magistrates, of course, whenever you are there and somebody is working under you and it is part of your adjudication, you have every right to interfere and to pass necessary order, whatever is required, right? So the role of protection officers, anything about the role of protection officer that I need to discuss, anything that I have left or anything that is bothering any of you, except your mobile phones, of course, you may please bring it to my notice. Anything about role of protection officers?
Sometimes
It's not working, sir. 1 minute, madam. Yeah, it's working now.
sometimes protection officer like make hands of person and protection ko lagi.
Sir,
Sometimes
sir,
protection officer needs protection from the like
He does.
Yes.
And you have, just like any citizen, first you have the right to inform the law enforcing agencies like police. More than that, your status under the law is you are a public officer. You are a public servant. So you have the entitlement of getting protection of that level. You are officer of court. Even a court cannot start proceeding under you, which is a weakness of the act, I believe, when you are not acting properly or whenever you have erred or you have defaulted by design or by mistake in performing your duty. Even a court cannot start a proceeding before you against you without prior sanction of the state, because you are a public servant. So, first, you have to rise to the occasion. You have to understand your status under the law. It is huge. No less than a magistrate, if I dare say that, I am repeating it. So you have every right to inform. पुलिस को तो कोई भी आदमी किसी को भी थ्रेट करे, पुलिस को आप इन्फॉर्म कर सकते हैं. OP, the term OP is used when it comes before the magistrate. So the first thing you do is inform the magistrate. Right? Whenever there is a threat, because this is nothing but contempt. You construe it properly. A threat to a protection officer in an undergoing DB Act proceeding is nothing but contempt of court. Right? Because the OP is not only breaching the order, he is preventing you from acting as per direction of the legislation and of the court. So you bring it to the notice forthwith of the court, and the court will start proceeding as per section 32. It is a breach, right? So that is the first thing that you can do in addition to lodging complaint or FIR. In addition to, because your right as a citizen and your right as a protection officer, there is no conflict between the two, right? Anything else about protection officers? That is it. So, what else are we left to do here? First, I have brought some judgments that are, I think, that may be of use to us, all of us. These are all hodgepodge. आगे पीछे हो गया है. I have just listed some judgments, and I am telling you this is very bare a collection. You can have, nowadays you people have all the AIRs online, SSC online, Google to hai, whatever sites are there, you can go through it. So this Kunappa Reddy case, it is important for 2-3 things. First, about amendment. Second, about interim maintenance, also they have discussed. About procedures also they have discussed. So the procedural part and this amendment and all, for this is important. You can go through it. See, the language used is Even in criminal cases governed by CRPC, court is not powerless and may allow amendment in appropriate cases, right? So that's an amalgamation of both. About jurisdiction, as Madam was saying, in Syamlal Devdas case, protection of Honorable Supreme Court held, protection of women from Domestic Violence Act, jurisdiction of court held. A plain reading of section 27 makes it clear that petition under DV Act can be filed in court where person aggrieved permanently or temporarily resides or carries on business or is employed in present case, respondent residing with her parents within territorial limits of Metropolitan Magistrate Court, Bangalore, thus in view of section 27, Metropolitan Magistrate Court, Bangalore has jurisdiction. But this is in addition to, she can file a complaint from her father's place. She can of course file a complaint where the cause of action arose. That is the normal process. Like I said many times by this time that whole of CPC and CRPC you can use. So the jurisdiction thing as laid down in CPC is applicable here, right? She can file a complaint where the cause of action arose, where the parties last resided together. Those things are all there. As well as in addition to this, where her parents reside, as Supreme Court said in this case. So it is like, how to say, it is like an NI Act case. You have like multiple jurisdiction and multiple areas you can use, and the complainant is spoiled for choices. About execution part we have discussed, we can discuss later. About jurisdiction, protection of women, again they have given person against whom maintainable specific government. I forgot that this is a touch screen laptop. Our Honorable High Court has provided it this in 2024 only. We have a touch screen laptop. So when I was dealing with it, I was reading it and it acted on that. So our High Court is very kind on this. So don't pay any attention to that. High Court is better. You don't record that. So primary satisfaction of court. When we discussed it in our first session, that a complainant comes to you and tells you this and this has happened, you can write an interim order on that. It sounds very, it reeks of lack of, I have audio antrim part-time as the OP. It reeks of, it shows that how can I act on somebody's statement. So Honorable Court said in Chamlar's case, you have to have prima facie satisfaction. How your prima facie satisfaction will come to you? Ask your judicial concerns. The judicial common sense that you have earned sitting there, you will hear her, you will see documents if she has any, because in all cases, if somebody is ousted from the house, what document will she bring? मैं ससुराल में रहती थी, मुझे घर से निकाल दिया, क्या document है आपके पास? If you ask for a documentary corroboration, you are failing. You cannot. You have to be very pragmatic there. Sit down, think of people, women living in your society and your surroundings and family. Think of yourself. If you have had fortunately a very, economically underprivileged upbringing, it's a fortune. I trust it. It's a very, very fortunate thing to grow up with very basic necessities if you are to be a judge. I studied in a government Hindi high school. Till class 4 we were sitting on floor. From class, there was a chatai on floor, of course. It was not bare floor. And from class 5 we used to sit on benches. We used to sit on benches where, say, bench is made for 5, there were 7 girls. And it was the concept of girls' school in government schools was not there. I don't know nowadays if it is there. So the boy used to sit on other side and you were not supposed to talk to the boys and the boys were not supposed to talk to you. If you talk, there was strong exception taken by the teachers and all. That was a perception. And I am very, very fortunate and I am very happy that I grew up there, because there are situations I understand. I am more qualified to understand than those of us who have had a privileged upbringing in a very privileged convent school where rich people's children come, So they don't talk of incidents when आज खाना नहीं बना क्योंकि बाबा माँ को बहुत मारे थे सुबह, तो मैं स्कूल में आया बिना खा के, टिफिन तो भूल जाओ. The concept of taking tiffin in school was not, it did not exist. It did not exist. खाना खा के स्कूल आओ, घर जाके खाना खाओ, हाफ टाइम में सिर्फ खेलना है, टिफिन टाइम खेलने के लिए होता है. The point is, I was not poor. My father was not poor, of course. I'm sharing it with you because I understand that my father understood that studying in a convent school was not what will make you how to say a proper sensitive human being, and I guess he was right there. So all my brothers and sisters, all of us, we studied in very basic school. Our जो हमारे धोबी थे उनके बच्चे हमारे क्लासमेट थे. वो आपको बहुत ज़्यादा रिस्पेक्ट सिखाता है, वो आपको बहुत ज़्यादा एम्पैथी सिखाता है और बहुत ज़्यादा रियलिटी चेक होता है लाइफ में, और वो इम्प्रेशन जो है वो रह जाते हैं. तो यू डोंट ग्रो अप, you know, you learn speaking in English down the road when you have to, but I believe that we have to make talking about it a comfortable thing because this is real. हम आँख बंद करेंगे तो ऐसा नहीं होगा कि हमको कोविड नहीं होगा, you know. So if it is happening, let's start talking about it. Let's start, you know, discussing it as a common normal thing. This is not something that adds to your qualification or makes you disqualified to sit in a swab judges conference. It does not. Rather, it makes you more qualified to understand how things work. I take pride in saying that. I was very happy when I heard in a meeting in long back, Aishwarya Rai said, the heroine Aishwarya Rai said, I have been a victim of domestic violence. It takes a lot of courage, and it makes you feel that, okay, fine, it has happened with you, okay, fine. You are not any lesser human being because it has happened with you. Because we tend to put it on victims. The fact that we were discussing during the recess period that women are not coming forward because first thing is that the system, everyone starting from police to judge also. We have to admit it to cure it. आप जब तक मानेंगे नहीं हमको खांसी हो रही है, तब तक आप डॉक्टर के पास जाएंगे नहीं ट्रीटमेंट के लिए. We start with the premise something should be wrong with the woman. We should stop doing that, right? So, prima facie satisfaction of court is required to start working with the interim order or that interim order of residence and all that, right? About interim maintenance, there's a judgment. Now we are discussing judgment, so there's an overlapping thing, but I have to give it to you, although it was not part of this. I think it will help you understand better how Domestic Violence Act works. In Ajay Kumar's case, Honorable Court said that what happens is, वो father-in-law के साथ रहती है, joint family में रहती है. Most of the Indian households are like that only. It's not like a unitary family and husband and wife living together. That is rather a rarity and a metropolitan thing, not happening in villages. So they live in joint family, and the husband either is working somewhere abroad or outside, or he is dead. Whether he has deserted or not, वो तो अलग question है. Now the maintenance thing. Now the resident order things. The court can very well order it against the close relatives of husband. The court can very well order it against the residence order against the father-in-law, mother-in-law, and the family members also. If it was a joint household, if we are living in domestic relationship, right? So that's what Honorable Court said in Ajay Kumar versus Lata. There are other cases also. I just took one case of one topic so that, because what happens is, you are all aware, when you read a judgment, you come across at least 4 or 5 other references. Especially Supreme Court, they discuss. At times I'm so tired. Why do they discuss all these things? This was only the issue. They discuss it because they are wise people. They know that you will take up this issue, you will be forced to read all the judgment, and you will get to know so many things. वो आपको बाध्य करते हैं पढ़ने के लिए. ऐसे तो पढ़ते नहीं है हम सब. We are all, you know, the efficient people we are. We have so little time to read. So that's why they discuss everything. That's why now I have understood with age. Wisdom comes a little bit of it. So now I have understood. They push in all the relevant judgments. In Rajneesh versus Nya, they have discussed so many things. You have to read the judgment once. Like you have to, please do something, I have to request you. Read the whole of DV Act and the whole of rules. ज़्यादा नहीं, 15-20 पेज. But I am sure most of it, if not all, have not read it cover to cover. जब जो सेक्शन या रूल लगता है वो निकालते हैं, पढ़ते हैं, काम कर लेते हैं बस. मैं भी यही करती थी. Don't do that. जब भी मन करे एक बार कम से सिर्फ एक ही बार पढ़ना, जैसे CRO सिर्फ एक बार पढ़ना, बट पूरा कवर टू कवर पढ़ना है. वो तो मैं भी अभी तक नहीं कर पाई हूँ, बहुत बार सोचा है, बट बहुत जरूरी है. और you will find, you will understand it if you read it once. Just like a novel, ऐसे ऊपर ऊपर, you will find immense information there, CRO and CRO. You will find immense information in the DV Act and DV rule. सिर्फ कवर टू कवर पूरा एक बार रीडिंग देना, सिर्फ एक बार. कि मैडम ने बोला था चलो बहुत बुरी नहीं थी, एक बार सुन लें. जस्ट एक बार अगर कवर टू कवर पढ़ें, you will read lot of things are there that we do not even know, right? And only simple reading. Legislators have done an awesome job in most of the legislations, and we can use it. We are the ones for which it was written. We are the ones. You have to understand, lot of constitutional, lot of discussions, lot of parliamentary debates have gone behind every single legislation. We have to understand the value of it. Every single word was used in the law of interpretation. They say every single word was used consciously. That we have to please adhere to. Right? So Lalita Topo, there are a lot of things. One is that who is the aggrieved person they have defined. And there is appellate would be efficacious remedy to seek maintenance on the provisions of DV Act such and such. The victim, that is estranged wife or living partner, would be entitled to more relief than what is contemplated under section 125. We have discussed it. Judicial separation, this thing was like, there was a judicial separation, so they were living separately. Judicial separation is they were living separately. Okay? Judicial separation means they were living separately. So then there cannot be DV Act. Think about it. DV Act, the whole idea is they were living in a domesticated household, in that whatever relationship. They were living in a shared household. Judicial separation by its very word meaning is they were living separately. Physically they were living separately. That is the only part. But isme bhi, Honorable Court has said in Krishna Bhattacharya versus Sarthi, so this is one of the landmark cases you should read. Case में recovery of स्त्रीधन, कुछ part is there of DV Act that can be applied even in case of judicial separation because the status is remains the same, she remains the wife, right? Does not change the status, so she can claim remedy under this law also, and she will be treated as an aggrieved person. Economic abuse can happen in judicial separation also. He may not provide or he may take away her salary. There are means. There are people who maintain joint accounts. Mostly women do, which they should not, of course. Mostly women do, and the salary comes, and there are ways and means of economic abuse, even when they are not physically together. Residence order, entitlement, this is Manmohan Attavar. We are reading that is coming there. What are the requirements when you can pass this interim ex parte order, especially in case of residence order, that is detailed here by Honorable Court. Complaint under DV Act can be filed against females. This was not there in the Act. Initially it was only against men. That by definition females were not there, right? In DV Act the complaint could not be filed against males as per the definition of DV Act. But Honorable Supreme Court has held in many various cases that complaint can be filed against females also. They will not go out of the ambit of the Act. Now this is an interesting situation. In Archana Khandelwal's case, what happened was, Honorable Court has held that the landlord cannot be made to suffer. Now the situation that often comes is, they are living in a rented house and the husband leaves, simply leaves. Wife is left, he stops paying rent. What happens? The landlord cannot be made to suffer, Supreme Court said. Now I understand that in seminars and workshops we are at liberty to discuss and even criticize some judgments so that we can evolve and we can be better than that. I'm not due respect to every judgment that we are discussing. This is something, this idea should be there so that you can understand, because that judgment was written in a particular situation and fact circumstances which may not be there before you. So you don't just say, landlord cannot be made to suffer. Honorable Court said in Archana Khandelwal's case, so the landlord will be given an eviction. No, no. That is not how it will work. If you see that the husband has deliberately stopped paying rent, you have to look at that. Even if the civil court ends up giving an eviction decree in favor of the landlord, the due process of law thing will come and the husband will have to be provided. There has to be a rider to that, and the husband will have to provide an alternative accommodation to the wife so that the landlord can have eviction decree executed. This wholesomeness has to be there. You understand? And it is for the protection officer. You have a big role to play there. When there is an eviction order, you will come to know because the victim will come and tell you कि वो मकान वाला है, अभी वो रेंट नहीं दे रहा है, उसने नोटिस दे दिया है और मुझे उसने बोला है कि वो खाली कर देगा. You have to bring it to the notice of that court. And a civil court, even a civil court who is dealing with the eviction suit can discuss whether she was in a domesticated relationship, can discuss if there was a shared household or not. You understand? Even a civil court can discuss whether it was a shared household or not and can write appropriate orders. Okay? How they will do it? Whether they will use the protection officer, because in civil court you have 151. You have like lot of inherent powers. You can go out of your way when the law wants you to. Right? You can simply not write, okay, eviction order ho gaya, sab homeless ho gaya to ho jao. That is not how a court works. Right? So you have to have a holistic, you have to have a very harmonious construction of all these acts when this fact comes to your knowledge. When it is not within your knowledge, of course you have no way. But this judgment of Honorable Court has to be construed in the light of whatever facts are there before you. So this Senior Citizens Act was also misused rather, for ousting a daughter-in-law. When this judgment of Vanitha versus Deputy Commissioner, there have been other judgments after this and before this also. A mother-in-law or father-in-law goes to court and says that I need protection, and the wife, daughter-in-law is the accused. So the Senior Citizens Act protects him, the senior citizens, and the Domestic Violence Act protects the wife from not being ousted from that home. And in all probability, the Senior Citizens Act is invoked by the design of the husband so that the wife can be ousted. You understand? So this is a cock and bull. This is a situation where Honorable Court also ended up saying you have to have a harmonious construction of the two. It stopped there. It did not, Honorable Court in its wisdom, did not say you have to prioritize this act or that act. You cannot prioritize actually. There has to be a harmonious construction. How will you do that? The court deciding on Senior Citizens Act, that is an executive court. The Senior Citizens Act jurisdiction lies with the executive magistrate, not with the judicial magistrate. He doesn't have any inherent powers. He doesn't have DV Act powers, but he has protection officers. So when a Senior Citizens Act complaint comes to an executive magistrate, the protection officer will know how. The AP will inform. Because she will be an OP in that case. She will be an accused in the Senior Citizens Act case. Once you come to know, you lodge a complaint before the judicial magistrate, the DV Act court. Right? So the appropriate direction is passed by the judicial magistrate. A Senior Citizens Act court, the executive magistrate, does not have authority to write an order saying that the husband will provide an alternative accommodation, because it's dealing only with Senior Citizens Act. And they don't have any authority except whatever is there in the Senior Citizens Act, which is made primarily and ultimately for the protection of the senior citizens. So what they will do is, they will simply write an order in support of the senior citizens, in favor of, to protect them. They need protection. Having everything, like all the discussion we have had, the protection for senior citizens cannot be undermined. At the same time, we cannot just overlook the existence and the survival questions of the victim, of the lady. Right? So there the protection officer will lodge a complaint under section 12, will inform the magistrate to write an order under DV Act, putting it on the husband or the close relatives in absence of husband to provide for an alternative accommodation in the event of senior citizens having any discomfort or disharmony by the existence of the wife. Right? So, Honorable Supreme Court said on harmonious construction. How that will be adhered to, how that will be achieved, that is on all of you. And there are some must read. This is my limited understanding of this Kamachi's case and Satish Chandra Ahuja. They have discussed the whole DV Act in lot of details. Like you will get at least I don't know, many cases in both of them. They have referred to every single aspect. So this is something that you may look at. And now we have about this domestic incident report. Also, I have listed some judgments. What is to be done by the protection officer while preparing the DIR, what are the requirements and what are not, and all of this you will get in your the PPT that I have shared. I'll request them to share with each one of you. Your email must be there with the academy. The academy will share with you, and these judgments on DIR must be read by the magistrates also, because see, when the protection officer fails to give certain particulars in the domestic incident reports, you can ask for it, you can call for it, and you can look at the DIR with a proper perspective with the help of the judgment that Honorable Court has laid down the whatever. Now, we have one important task at hand, which I have requested the learned Deputy Director to circulate to all of you. The syllabus says writing a gender sensitive judgment. What does it mean? What does it mean, sir? Tell me. I have been speaking a lot. I need some water. Writing gender sensitive judgments. Tell me. You have been writing judgments.
So gender sensitive judgment, as for me, would be writing a judgment without stereotyping it or without.
And what is stereotyping?
From a perspective of.
Give me an example of stereotyping. I am enjoying it. Tell me, what is stereotyping? An example of stereotyping. An example.
Like a societal notion that women should work under the control of husband, should not own, should stay at home, manage a household.
Right, absolutely. Absolutely. Well said. Madam, you tell me, what is gender stereotyping? Give me an example that will do. Any example. Any advertisement, any example, any discussion will do.
In advertisements, usually when it comes to food, always the wife is cooking in Indian advertisements.
Absolutely. True. Naturally. It's difficult, I know. Being a male is very difficult.
I think that's the thing. The society majority perception is that women, they have to be, they have to work in the home.
True.
And not be working outside.
That's a very big stereotype. Ma'am.
I think bringing up children is the sole, at least
Responsibility of the wife.
responsibility of the wife. Taking care of them, leading them.
True. Madam.
And I can think of the best example as the Mathura rape case controversy. Whole controversy.
No, you have to describe it. We do not know what the Mathura rape controversy was.
So this victim was raped by a policeman in the station, and even the Supreme Court judge at the time said that she was habituated to sex, she was not a virgin, she was already used to having sex. So her rape was actually justified.
Absolutely, very well said. So, madam, I have discovered my chocolate now, so I'll be eating it now. Now, the point is, you see advertisement of even insurance companies till a few years back where save for son's education and daughter's marriage. It was never for daughter's education and son's marriage. Son's marriage also costs equal. बेटी की शादी में भी आपको रिसेप्शन में पैसा खर्चा करना होता है, but the advertisement was same for son's education and daughter's marriage, right? Fortunately, things are changing. All the fairness creams, nowadays there are fairness creams for men also, but it was always that. You read the matrimonial ads, you will understand societal stereotyping. Now, we are in a very unfortunate and unpleasant position as judges. When Madam discussed Mathura rape, Madam said what Supreme Court or what our higher courts, those who lay down standards for us to follow, they mentioned the sexual habits or history of the women who was subjected to the gruesome tragedy. The interesting part is, in this handbook that Honorable Supreme Court has released, Honorable Justice D.Y. Chandrachud released it a few months back. They have interestingly discussed the judgments passed by Honorable Supreme Court, and I was very happy to see it because there are very few occasions when the Honorable Court criticizes themselves. You know, we never do. I am not doing my job, but this is a book where they have discussed all of this, all the incidents. There was a Supreme Court judgment where the Honorable Judge wrote that the victim was menopausal. I'm a menopausal woman. What's wrong with that? What's wrong with that? Come on now. My femininity doesn't reduce by having a certain biological cycle or not by having it. How is it reduced? A POCSO court pays so much of importance to a child, very rightly so. So having menstrual cycles is of no consequence to being a woman. Even belonging to a particular gender doesn't have anything to do with the offense of rape or of molestation or of sexual whatever, perversions and transgressions. But our Honorable Court said that the victim was menopausal. So Supreme Court had to come very hard on things. One Honorable Court, my Honorable Court, a few days back said that girls of certain age should restrain themselves, certain this and that. You know. So when Supreme Court released this book, they have discussed not judgments of magistrates or session judges. They have discussed judgments of Honorable Supreme Court and of Honorable High Courts where there has been gender stereotyping of women. When DV Act, Madam was saying, DV Act, women is not coming, people will say, something should be wrong with the wife, तभी तो उसको मारा है. हस्बैंड क्या करेगा? वो ऐसा गलती करेगी तो उसने ऐसा किया तो. This gender stereotyping that has been discussed at length, and I dare not read this. It's like many judgments and awesome. It's like I'm so impressed. There are very few times when I'm so impressed with. You know, a behavior has to be ladylike. I've been told I don't walk like a lady. A lady must walk with her head certainly bending forward. A lady must walk soft and slow. You know, a lady must use this, the lady must not use this. Nobody would ask him to wear a dupatta. And I wonder why. I literally wonder why. Because biologically whatever we are. But there has been an instance, this sensitivity is not lacking only in judges. It is lacking in judges. That is a primary premise with which we start. Otherwise, Honorable Supreme Court never needed to publish this book. You know, the fact that this book was published by Supreme Court shows it is accepted position that we do gender stereotyping. We use these words. Even advocates I remember I was a additional chief judicial magistrate and there was this 125 case going on. And the lady, she loved to dress up. What is wrong in loving to dress up? That's why I live. That's why I'm a woman. I wear all the lipsticks. Why not? That lady used to dress up a lot and the lawyer once said she was on dock. And the lawyer told me in English, believing that the woman will not understand, she was a Bengali village woman. She said, you only look at her and you will understand what is wrong. And I was so outraged. What do you mean look at her and understand? Why do you even look at her? You know the look, the look, you know, why do you even look at her? She is properly clad, there are shimmers on her sari which are awesome, and she is dressed because she is coming to a place where she believes educated people will there, so she should be presentable. What is wrong with that? Even for none of these reasons, she loves to dress up. Why should I look at her and make up? I said, shame on you, you have taught yourself law. You are a respected person standing here. You have at least half of Katwa subdivision's briefs in criminal law. What are you doing? This is what you are teaching at home. Look at a woman and understand. You don't look at anybody and do not understand anybody. I have seen a person sweeping the road being one of the most wise persons in my life. You can't look at somebody, his attire and understand his upbringing, his culture, his psychology and his philosophy. You cannot. That's beneath a human being. That's beneath. But this is required and it happens with us also. We as judges, we cannot keep ourselves out of it. We have to start with ourselves. That's the basic of every growth, evolution or reform. Start with ourselves. हम बदलेंगे दुनिया बदलेगी. हम नहीं बदलेंगे तो दुनिया नहीं बदलेगी. It's not like the society has to change. You know that march that was taken on that claim the midnight on the night of 14th of August in Kolkata. I took part in that. I cannot say that officially, but I did. As a woman, I thought I owe it. The mindset has to change. There were questions. Why isn't it stopping? We have such stringent laws. We had Nirbhaya, the CRPC, IPC, everything was amended, and we have a lot of stringent laws. Only the execution part, and that starts with us. We have a lot on our shoulders. It's not like police is not working properly. So the police investigation is to be supervised by the magistrate. Why are we given so much of authority under the law? The law actually believed, the legislatures actually believed that everyone will falter and it is for the magistrate. Everyone will falter. And it is on the magistrate to look that nobody does. That is why so many awesome powers are given to you. You can direct the IO, you can supervise the investigation, you can do a lot of things. Even under CRPC where there is no inherent power for the magistrate, you can do a whole lot of things. You can alter the charges when the charge sheet comes to you. You can do a lot of things. So when you are writing the judgment, when you are recording the evidence, when the witness comes to you in court, when somebody is looking at her, making her causing discomfort, making her uncomfortable, take care of these. You are the master of the court. Use all your humility. At your hurt, you have to get rid of any arrogance, and you can take care of it. You can request them. That's why we have on-camera trials. Because women are not comfortable speaking to men. We are not comfortable speaking of our ordeals before men because we think they will not understand, which may not be true at many times. I am not disrespecting any of our species. We are human. Women are human. We have to start with that. Each one of us. It is not for men only. Many a times it's a women who torment women. So gender stereotyping, mother-in-law stereotyping, father-in-law stereotyping, husbands and wives stereotyping, not done. Just not done. And when you are writing it, how you can be cautious, you know. This handbook is really good. They have even used. I have had a judicial order where an appeal court used the word bastard. The children were bastard. I saw that with my own eyes, with all responsibility I am saying that. It was way back, it was like 22, 23 years back. But I read that word. And now Supreme Court has said, you don't use bastard, you don't use affair. Affair is a very common word we use, very common. Depositions में तो लिखते ही हैं, judgment में भी बहुत commonly use होता है. She was having an affair, or he was having an affair. Pleadings we cannot help. Pleadings is not part of our business. That is done by them, they write whatever they have to write. But when we are translating it in our judgment, when we have to reflect it in our judgment or our this thing, we have to be very cautious. All the words, prostitutes, victims, all the words that have been taken care of, Honorable Court has laid down किस word की जगह कौन सा word use करना है, ठीक है? So this thing I think we have to read it, you know. If we don't read it, there is no point distributing it and wasting so much of so many papers and trees in the process, right? How do stereotypes work? Understanding stereotypes. See, I do not believe in any stereotypes. Why should I read this? So the researchers have shown that most of us hold some subconscious biases, which we may also not be aware of. But we have to dig deep and we have to find out. If we read, we will understand. Judge may also unconsciously hold or rely on some stereotype. We may not be even conscious of that because this is so much part of our growing up. A mother cooking, like Madam said. A father going out for work. Ladies were there because that profession was meant to be. Engineers, my ladies were not there. So those things are now changing. The people are trying to inculcate these ideas into very young minds, and we, by our very judgments, we have to start doing it because we were not born, most of us were not born in an atmosphere where we were very sensitive to these or how it affects us. Nowadays we are. I have had an occasion where a lawyer saying, Madam is looking very good. I joined after a lot of time. And in the process I was sick, so I was on leave, so I became thinner. Madam was looking very good. I said, thank you, but have you ever, and it didn't happen long ago, it happened when 2017-18, I was in civil court at that time, and I said, thank you so much sir, but have you ever said this to any of my male colleagues? Have you ever? Now, you do not associate the virtue of being beautiful to a man, you associate the virtue of being intelligent to a man, you know, being smart probably, but you do not associate the virtue of being beautiful to a man, and you do not associate the virtue of being intelligent to the woman. A woman doing well would be called, she is so ambitious, and this word is not used as a flattery. This is used as a, if there's a fallout, I have heard lawyers arguing when there's a divorce thing or anything like that, that she is very ambitious. What's wrong in being ambitious?
Aggressive.
Yeah.
People are called aggressive.
Yeah.
They have just been
She's very aggressive, very upright. These are virtues. Don't be tolerant. Don't be tolerant. I mean, that's my standing, that's my statement. Be audacious, why not? The point is not about the virtue. The point should not be lost in this discussion. The point is associating a particular virtue to a particular gender. That is stereotyping. All people who wear dhotis or are living in villages are illiterate. This is just associating. Somebody has come up with a suit pant tie, must be knowing English. No. No, these are stereotypes, these are not true. This is how our mind is made up. We are wired to think that, okay, this is how it works. Good women are not raped. If you dress properly, you are not raped. This is total crap, if I can use that word. And now we have come to a place in civilization to understand this more than anybody else, the judges. because we are at the place where all the wrong that occurs in society comes to us at some point of time, and you can see all its aspects. You can see the witnesses talking about it, you can see the opposite parties talking about it in civil proceeding, you can even see the IOs talking about it, even the police persons say that. So there you have to, your gender sensitivity has to be much more. When you are a judge, you are not a human. You are actually under the law put at a very high pedestal like a god. You can write that somebody is entitled to live or not. You can write a death sentence. You have to understand your responsibility. It's huge. You are almost treated like God in the system. So you have to acquire all those qualities. You have to be very cautious in your behavior, in the language you used, in your judgments, in your orders, even in your orally when you are speaking in court, you have to be very cautious of that, right? So this is the impact of stereotypes when it comes in judgments and newspapers and all around it is there, and I am to like we are shamed by it. What? Your one judge said that means we belong to the same community? No, we do not. Those are higher courts, much higher, but still we also in our own little capacity wherever we are writing it, we have to be very cautious. Can it be overcome? Of course it can be overcome. With consciousness, with awareness and being alert in, as I said earlier in some part of our discussion, that we have to be very conscious in our choice of words, whether we are speaking, whether we are writing, and that consciousness will also lead to elimination of gender stereotyping, right? What do we need by gender, how gender and sex are different? These are things that have been discussed in the handbook in detail. Like even in case of IU, I have heard cross-examination. आप AC थोड़ा कम कर सकते हैं सर? सर को ठंड लग रही है, मुझे भी लग रही है, समझ में आ रहा है. Like even the IOs, even the cross-examination of IO, there has been lady IO, and there has been cross-examination that you were emotionally swayed. Now this emotional swaying will not come to a man. This suggestion comes when there is a woman. That you were emotionally swayed by the victim, by looking at the victim, because she is a woman, you are a woman, so you are doing this. So these are some gender stereotyping that we are, to deal with. And this book, I am afraid you have to again read it. They have discussed a lot of cases, Mathura case, that is Bhavri Devi's case. Bhavri Devi's case is there at this time. It was there. It is there on page 19, right? So they have discussed very many cases. I am very happy about that. Most of the pages in the last part, page 22, they have discussed this case of Aparna Bhatt, where Supreme Court said to say that the survivor had in the past consented to such a similar act, or that she behaved promiscuously or by her acts or clothing provoked the action of the accused, that she behaved in a manner unbecoming of a chaste or Indian woman. These are stereotypes. This whole para is not stereotype. This whole para is to break off the stereotype about the sexual behavior. But in doing so, Honorable Court has used words like chaste women, Indian women. These are stereotypes. Or that she had called upon situation by her behavior, etc. These instances are only illustrations of an attitude which should never enter judicial verdict or order, etc. So a lot of discussion is there. Joseph Shine, lot of cases, State of Jharkhand versus Shailendra Kumar Rai, where the two-finger test was banned by Honorable Court. But let me tell you, I don't know about Sikkim, in West Bengal, it is still going on, and it is going on around. In Bengal it is going on. In Kalimpong also I got a case where it was done and the doctor said on doc, I did not know about any such judgment. That was in 2023 or 4. I was there in 3 or 4 only. So it was maybe not rampantly, but it is being adhered to, and people are mostly do not know. Gurmeet Singh is again another important case whenever we are reading it. This is Chote Lal prosecuted. The Chote Lal case, Supreme Court discussed this, habitual in and all that. So they have not hold back in discussing the places and areas where honorable courts also reflected a tendency of this thing. we are at the almost the end of our discussion and our meeting today. Last few minutes are left for us to talk, not to hear only, and tell me whatever you have to share. How was it?
Very interesting.
Very engaging.
Very engaging.
Was it? Write a good review so I'm invited again. Don't record it. Yeah, please. No, jokes apart. Whenever you do a domestic violence act in future, and I will include, although that's not part of my itinerary, I will include 354, 376, whatever POXO 4, 6, whatever comes to you, it will very soon. Your magistrates already 354 and all these things you are doing. These are the parameters with which we will work. First, we will remember, I'm not a judge. I'm just given this job because somebody has to do it. I'm not someone who was specially made by God and sent to earth, right? So I'm as good or as bad as any other average human being, and I have my sister, my mother, my daughter, my granddaughters also, if God willing, and I have to be as empathetic as a human being can be, because no one is safe. And each one of us, with our security, with our people, with our office, our infrastructure, each one of us, our families, each one of us are equally vulnerable. So if I fail to do it today, tomorrow somebody else may fail it. And I will not like that, right? If I remind myself every day that this victim could be me. See, as judges, you have to learn a lot of theatre. You have to put your foot in the shoes of the victim. You have to put your feet in the shoes of the accused when you convict him. You have to do lot of role plays. I totally believe that. Whatever I told you, in all honesty, each one of it is what I have heard and what I have practiced. So I believe, just see, each one of us is a judge in our own right. You got the job because you are qualified for it, right? अपनी शक्ति से, अपनी कैपेसिटी से इस जगह बैठे हैं जहां आप बैठे हैं, आप सारे के सारे. So there is no one who can teach you better than what you know already, right? What we can do is experience sharing only, because I have had the advantage of being old. I have been here for 26 years, so I have seen more cases than you have, and that's just time. That's no qualification. It will happen with each one of you. After 10 years, you will be as good as I am today, or as bad as I am today. After 15 years, after 10 years, or whatever time, right? So what I learned is, quality you can always acquire. Empathy is something you have to practice every day, and honesty is something that you have, right? And these are the three qualities that will make you what is expected you of as a judge. A lot is at stake when somebody comes to you. जो बहुत normal cases होते हैं ना, वो bailable matter है 323 से अच्छा 500. You know, I was in Shalda, I was a judicial magistrate there, so we had to do police file by rotation. Those are big courts. Big court means more cases, nothing else. So what happened was non-bailable records, they will use to bring like this. Like this means it's like, you know, record, they are holding like this. So it's like 100 records, 50 records like that. These are all bailable matters. So you only write the amount. The magistrate will only write, actually, it is not possible for them to hear. So they will only write amounts. I was blessed with the idea that I have to waste or use my time. So I used to even look at those records. And trust me, there has been situation, one particular situation I remember right now. 323 was there, and I just used to just look at the FIR before writing the amount. So I looked at the FIR. The FIR was the husband has cut the whole of the throat of the wife by a blade. पूरी तरह से. Was it 323? कुछ नहीं हुआ था वाइफ को, कुछ हुआ नहीं था. There was a mark of the blade on all around, but it was 307. It was not 323. Neck, nobody would move the blade all around the neck only to cut. Nobody would do that. 307 does not require any actual injury, leave-aside injury qualifying for death, capable of causing death. Leave aside that. No injury is required for 307. And they put a 323. So the fact that I took time to look at the record, I could send it back, I could write the order, say look here, this is not 323. You have to start a case under the proper provision of law, and I sent it to the superior also, and it was a 307 case. When the wife came to us, which came at a very later stage, their statements in 323, you don't have a victim statement. Nobody goes for 164 and 323. So when you bring out some time understanding that every single record, even if you have 2, even if you have 2,000, does not matter. Every single record has only one or only few victims. It is not about the number of records you have, number of cases, right? Every single case involves life, and they have a lot at stake when they come to you. You have to use that much empathy to deal with it. Thank you so much for bearing with me, and I'm so glad and grateful, and my heartfelt thanks to the Academy, to the Honorable Chief Justice Sikkim, to all of you for having me here. Thank you so much.